Good morning, everyone. Welcome to It's a Crime. For those of you who don't know me, I'm Linda, and today we are at closing arguments already in the Lori Vallow Daybell trial. We are seeking justice for Charles Vallow, and it's gonna be an interesting one, I think, today. Let me know what you think. Now, before I went live, I starred some comments we'll talk about in a minute. This is hilarious. Time for the Shih Tzu show. Shih Tzu Barbie will be up to bat today. It's been a journey. I think we are all not surprised, but I'm surprised it was rested so early. We have seen a lot of evidence in the case. We saw a lot of random questions by Lori herself, and she chose to represent herself. They rested actually even a day earlier than we thought, which was last Wednesday. And then Thursday, we had some bits and bobs. So this morning, what they're going to do is there's going to be a hearing. Then the jury is going to arrive. Then they're going to, at 1 p.m. Pacific, they're going to do closing arguments. Now, last week, they said that closing arguments by the prosecution was only going to be an hour. And when Lori was asked, she just said, less than that. So we don't know if it's two words that has FU in them. We don't know what it's going to be. But remember in her opening, and I will show that, we'll try and go back to play that so that we're reminded of what she said in opening statements. And we could even play Trina's as well while we're waiting for closing arguments. We'll see how long it takes this morning. And the other thing is I have done a poll in my community tab. So if you have a moment, go to the community tab and vote on what you think is going to be the answer. Now, so far, we only have 387 votes so far, but I asked, what will the verdict be for Lori Vallow Daybell? 92% said guilty all the way. 6% said, I'm not so sure. And 2% said, no, based on trial, she'll be found not guilty. So this is interesting to see how that's going to play out in the day. Now, we don't know if it's going to be a verdict today or not. They have to go, the closing statements, but we never know because sometimes they come back in an hour, sometimes they come back in a day, sometimes it's going to be a few days. We don't know. Let me know what you think. Do you think it's going to be quick or not? Now, I'm just going to take that off the table for a minute so that I could bring in and get ready for when court walks in. Let me just double check. So that I could get it all ready. We're all up to date and ready to go. But we will put it like this for now. Okay, now, Polly says, I'm in the 2%. Prosecutor was rubbish. Tracy says, if the jury takes more than an hour, I'm going to wonder why. And Shiloh says, which I love this, so I'm going to confess, she says, I made green chili chicken enchiladas in order of Lori going to be found guilty, and I used canned chicken for the first time in them. My family didn't get my humor. I love you, Shiloh. That's hilarious. Andrea says, after I watch some of Linda's videos, I get her channel in my algorithm. Yes, yes, yes. Please check out the Brandon Boudreau case, the Idaho 4 case, the Charles Vallow, some of these live streams, non-live streams, and get me back in the algorithm so that you can be notified and know what the heck's going on when I come back. in my regular videos. Now, Buzzy Bee says, don't flatter yourself. Best line from the whole trial. It's Me says, her closing is going to infuriate us all. What do you think's going to happen? Now, we saw her climb up. She's getting angry, snarky, 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 snarky. And then Monday, she's chill. And then Tuesday, Wednesday, Thursday, snarky, snarky, snarky. Will she be chill this morning? Maybe she'll be chill this morning. And then 1 p.m., she's going to be, this is her last shot, right? It's her last shot, so to speak. So, let's go back to some more comments and then see if I have more to say in this. Yes, I am back. Stacy says, I hope you're back, little Missy. Missed you. Missed you too. I've been here. So now, once this is done, we don't know how long it's going to take. But once this trial's done, on May 30th, they're going to start jury selection for the Brandon Boudreau case. And Brandon Boudreau is Lori's nephew-in-law, or was nephew-in-law. He's still alive, but he had an attempt made on his life. Lori's being charged for conspiracy. And a bullet missed his head by inches. So she's going. Now, this is interesting because they're blocking out the first 2 weeks of June for it and the fourth week of June for it. Actually, pretty much all of it except from the third week, 16th to 20th. That's dark, which is what they call it. And people are like, oh, did he do a slam at Lori? That's what they call it. It's dark. Same in theater. And so I guess it could be say the same thing. It's like theater with Lori. And so I find that peculiar because it's going to be from Monday to Friday. We only had Monday to Thursday in this one, and yet it wrapped up in under 2 weeks. So they were estimating up to 4, and I even 3, and I still don't see it with Brandon Boudreau, but you never know. And Brandon Boudreau lived, so that's a little bit different as well. He lived to have a voice, whereas Charles Vallow, we couldn't see the body cams, which in a perfect world we would want that, but they can't. So there's that. Lori is right riled up about not being able to do her speedy trial by May 11th. Judge is like, you know what? Too bad for you. You can't do 2 trials at once. So forget about it. Fast forwarding, I was looking up trials for Brian Koberger, which is to start August 11th and the jury July 30th. I don't know if it's gonna, these things can be pushed out, but that's gonna be 3 months long, which is quite some time, and it's gonna be gruesome. So hopefully everybody can buckle up. Stephanie says the best part was Colby saying the enchiladas weren't that good. I don't doubt it. Oh, Sumi says, I watched the Brandon recaps you had recorded. Thank you for the timelines. Hello, Denmark. Dawn's Delights Art says she will play the victim card without evidence. Yeah, the evidence will show, the evidence will show, the evidence will show. What? Yeah, the evidence did show, Lori. It did show. Susan J says, I think it will be a closing sermon. And thank you to those who are moderating today. I very much appreciate you guys. Thank you for watching with me too. It's kind of fun, isn't it? It's been fun the last 2 weeks. Yes, we do want to know if that chick channel is well and her baby. We had a pregnant woman, a pregnant family member here who was in labor watching the trial. So we have it all here. Family's important, so we want to know. Now Buzzy Bee says back to baby voice. Joe says she will be well medicated. It has not already started. You can see on your right, on my left. We are waiting. Oh, now my voice is going. I could be like the 1A. Well, hello, Linda speaking. Okay. So, this is a question. Vending Guy 47 said, Linda, would you ever interview Lori if given the chance? I absolutely would. I absolutely would. I was hoping that I could be down there and look at her. But you never know. Maybe Brandon Boudreau's case. I don't know. Divine Hope says, I think it's going to be quick, but like how quick? Yes, she is representing herself in the Brandon Boudreau trial. The Dave that loves Star Wars says, good morning from Wisconsin. Lori's closing will be frustrating because she's going to keep trying to testify and the prosecution will have to keep objecting. I think this is interesting because here's where I think we'll see her, like you said, Dave, but put in her little sneaky sneakerson comments. We saw her trying to do that I shouldn't say once in a while because it was a while, but we did see her try to put these comments in and then there would be objections. But it was so random. I mean, last week she was talking about apple juice and bottles of water, and she's just an idiot, in my opinion. Peter Peterson says, hello, all become burritos. The evidence will show. Good kisser, date married men. What classic new thing will she say today? Isn't that the loaded question? What will she say today? She'll say the evidence will show my husband was dating while he was married to me, that my brother wouldn't talk about my famous cheesy chicken, green chili chicken enchiladas. And other people perjured. It wasn't me, that I was wearing shoes in the CCTV footage of going in to go get flip-flops. It'll just be a bunch of BS, but I really do hope. I've been saying this for 2 weeks. I hope that she loses her SHIT in the courtroom. We almost saw it on, was it Wednesday? We almost saw it. She started. She was elevating. We thought it was going to happen. It didn't. Claudia says, we will have a verdict today. I think we will. I don't know. We'll see. Maybe it's a slam dunk for these jurors. Maybe they need more time to deliberate. Oh, I'm sorry. Crystal Dawn says, there is no community tab. It's under posts. Yes, it used to be called community tab. And as a creator, we call it a community tab. Especially ones that have been doing this for over 5 years, we forget. It's under posts. And we will check what that is. Now, they did say it's only a 5-minute delay today, not 30 minutes. Ooh, 91% guilty all the way, and 7% I'm not sure, and 2% no, with 509 votes. So we'll see that as the day goes. Nadia says, what's going to be gruesome? The Brian Koberger trial and the details. Let me get you guys the poll. Yeah, this will be it. Feel free to comment in there. Have your say. Poll is posted there. Oh, well, that's very sweet of you. Thank you. Didn't sleep very good last night, but here I am. Maureen says, I think the verdict will be afternoon tomorrow. Oh, yes, and hit the like button. Do all the things. I appreciate it. And thanks for hanging out with me. Okay, yeah, so it'll be a 5-minute delay, but this morning they have a court hearing. Then we have jury instructions. Then there was something that the judge said the other day, and he said, oh, yes, the official intentions to rest by the defense. Because Lori did say it last time, and then he's still giving her a chance if she wants to. So I guess we get that. But she was supposed to give him the heads up. So who knows where we're at on that? I don't know. That was interesting in itself when we were hearing some of the amendments to the jury instructions. Lori wanted to talk about that a crime prevention assault, which was interesting. Ooh, Lori. I can't imagine. She angers us. I can only imagine how she does with her to her family, you know? Thank you, Heather. Feather. Pauline says Lori didn't put on a defense. I find that odd. I think in her mind she did. But she did give up on some of them, which was interesting. Maybe she started to realize maybe these um maybe her questions weren't as smart as she thought. Because they're talking about, let's see, text messages and the Cellbrite information, and she'd come up and go, "So, did you offer me apple juice? Did you offer me water?" And you're like, where are we going at with, like, where are we going with this? Michelle's asking Linda, if Lori gets convicted, will they give her the death penalty? We can only hope. There's no death penalty in this one, and but she will land her butt back to Idaho, is my understanding. And we'll see what's added on with this. She's already serving 3 life sentences for the murder of her children. Let's not even say death. The murder of her children and for her 5th husband's wife. So now we add Charles Vallow to the list and hopefully Brandon Boudreaux. It's too bad, though, that Chad didn't get that tacked on with this and also tacked on Brandon Boudreaux. Bebo says she will probably do the crocodile tears again as in her opening. Yeah. We'll see what happens. This is the fun channel. Yes, welcome, welcome. It is fun, isn't it, Sue? We have to. We have to be fun because half of it is not fun. Crystal Dawn says, I couldn't watch. I can't hear Lori talk or I'll lose my mind. I've done so many thousands of hours on this. Like, I hear you. I hear you. But this is so good to watch her. And I just like one of these that she just loses it. She can't do too much because she has a stun belt on. But just a little bit, just enough to be like, no, let her go. Take the leash off. Just let her go a little more and let her lose it. I'm surprised she hasn't yet. She almost did on Wednesday or Thursday. I think it was Wednesday. We saw it. Monday, calm as a cucumber. You wonder, like, did she meditate on the weekend? Did she pray a little extra? Is she given some medication on Monday? Or she heard what everybody was saying about her somehow, some way on these live streams, and it's like, oh, I better back up because I'm not looking as good as I thought. The stream is super glitchy. Is that for everyone or just on the live? We're still waiting for it to start. Vending guy says, I think will be a quick verdict. Guilty today. When she's guilty, my wife and I are having green chili chicken enchiladas, chicken fries, and Sprite for dinner. And cheers to her demise. And in her, what was it? Her interview with Keith Morrison. I didn't see all of it, but we heard her say that she had some sort of stupid vision that she's gonna be out or exonerated, and I just started laughing. I'm like, no, you're gonna be dead, Lori. That's what you're gonna be. Oh, Shiloh, thank you so much for gifting the 5 It's a Crime memberships. Thank you. Bowmeister says, Linda, you know what most of us feel. How do you think today will go? I think Lori's going to be agitated during her closing statements. It's interesting, though, maybe when she answered less than that, when asked how long hers is going to be, and Trina said an hour. And she's like, less than that. Maybe she spent the weekend fluffing it up a little bit. I think that it's possible the jury is going to be quicker than longer. There was so much in the previous trial, but not that much in this one. I just hope that the jurors put 2 and 2 together of like, wait a minute, where's Tylee? Where's JJ? Why aren't they speaking? You know, those kinds of things. I've said this before, but I would have preferred Trina to be a little more dominating in some of the words that she was saying and expressing in the texts. I feel like it doesn't have to be dramatic, but just a little bit more emphasis, I guess the word is. Like when we got rid of him. So what? She says it a little bit longer. Lori got away with how many things saying in court. So I would have put emphasis on that. I would have made it extreme, but well, maybe I might have. But if I was Trina, I would have just, so there's a couple things that I would have liked. And I said this before too. It was too bad that they talked about Lori's behavior, but I think it would have been more powerful if they did Lori's behavior talking about it and then do her video. Because they did the video first, and I don't think the jurors could have got it, but at the same time, I think it would have been more powerful. Oh, you guys are so sweet. Thank you. And Joe says, do you think she'll attack the prosecutor? Not without the stun belt coming out. John says, what's the over-under for Lori saying my husband? I don't know what the phrase over-under means, but she uses my husband when she needs to manipulate. And there's times that she said Charles. Now, one of the things, too, that she said, so weird about her husband is wanting to hear about the crunch when they did the compressions. And there was something else too, the bounce or something like that. It was sick. It was very similar to how Chad Daybell has dupers. Oh, right. I needed to do the Lori hair. Dang it. Maybe I'll do it. Maybe I'll do it when she's convicted. The Shih Tzu hair. Elroy says the evidence will show that bamboo underwear won't be of any use. In the trial, she's talking about this bamboo shirt and it's so strong. And she was to the point where she was saying basically that did the bullet holes were there any bullet holes in a bamboo shirt from I can't even say it, from the bullets. But it was shown that Charles was shot on the ground. He was shot in the second shot. He was shot on the ground because of what's something called shored wound. And he had an exit wound, hit the ground, and they were showing that as evidence. One of the interesting things, though, you got to admit, is during the testimonies of the police department, there was a lot of questions like, "Oh, you didn't test for that, you didn't do that, this wasn't done, that wasn't done." That was kind of like, but no. And even when Lori was taken into the police station with Tylee, and Alex went with his little boo boo, and that they were acting weird. They were acting odd. You don't act like that after 15 years of being with somebody and them being part of your family. Hi, neighbors. Sorry. I gotta warm up. I said, "Hi, neighbors. Sorry." I hope she loses her Shih Tzu. Victoria, you come up with the best lines. Let the bamboo shirt t-shirt acquit me. Michelle, Nini G says, travel fun to tell Lori her enchiladas are gross. You know what? Thank you, Nini G. And you know what I'll do is I'll wear it on, like, I'll wear like a nonchalada shirt right in front of her, and I'll smirk like she does in court. Just go, I gotta practice it. uh. Heather Feather says she literally didn't put on a defense. Surely that's at least weird to the jury. The whole thing was bizarre. I mean, she started off a little stronger. Michelle Bell says, can't wait to hear what will come out of Lori's mouth, right? Thank you. And Madame August Butterfly said, court is on, but I don't have court on. Not yet. We are this little square we should see soon. Oh, Suzanne says, hi, Linda. Did you watch Colby's interview with Ray? No, I did not. But we want to see if both will come on here. Laura G says, I think she will go into a whole lot of nothing. I hope prosecution will go into every detail. She's guilty. Since late closings tomorrow, verdict. Very, very well could be, or could be today. Maybe tomorrow. Oh, it's a 5-minute delay for the verdict, but the rest of the day is on 30. I misunderstood. Better early than late. Mona Lisa says, would love if you cover the Corey case in Utah. I have covered a lot. I don't know how many videos I've done in that case, but now I'm getting a hot flash. Let me just look. Corey Richens. I have eight videos on the case, and I will cover it, but I heard that they're staying it for now. So there's Corey Richens right here, if you'd like to look at that. Please give a little like, get that out there. Thank you so much. Yeah, Idaho 4 is going to be 3 months long. Oh, that's so sweet. You're checking in. Thank you for asking. My dad actually, my sister had to call 911 on Friday. My dad had to go back. He was out on Wednesday from the hospital. He went back into the hospital Friday night. He couldn't breathe. His blood pressure was low. And there was something else. Anyway, he's okay now, but he had to go back to the hospital. Sister called 911, so that was great. She did that. And he has pneumonia a little bit, so they gave him antibiotics. It was the start of pneumonia. That's why he couldn't breathe and he was not feeling so well. So he's okay now and he's back home, but he's still not feeling great. But we get to talk, so oh, Carolyn Knight says things on my bingo card. They never swabbed my hand or Alex's or Tylee's hands. Yeah. And Suzical says, I hope no conjuring of storms. No, no. Please, Lori, don't talk about that. She might go on a complete diversion. We saw diversions from the beginning. That's her pattern. She'd talk a little bit, divert, but interestingly, we could tell the ones that intimidate her because she knew it was no go. Like don't ask some of the like the fire chief. There's no way she's going to ask because he wasn't going to put up with her crap. So, but today she gets to say whatever she wants. So, within reason, but she might use that just to say, here's this, here's that, which is nothing to lose at this point. She thinks she has every, what I'm saying. She's just going to say diversion. Like, I wasn't afforded my rights to have a drink. I didn't get apple juice. I didn't get water. I didn't get my butt kissed. I didn't like all this kinds of stuff. We'll see. Okay, okay, so you know what? Since we have a little bit, why don't we play? Would you guys like to see we go back to opening statements? They were supposed to do a court hearing. Actually, it might be in 8 minutes to be fair, because it was 10:30 Pacific time. If we are still sticking to the half an hour delay, then in 8 minutes it'll start. So if you can do 8 minutes of me talking, or we'll answer some questions, we'll see how the poll is going, and then we'll do the hearing, and then I can play the opening statements again if you'd like, and we can talk about that way we have it fresh for what the closing statements are going to be. And we could start with Lori so we can listen to what her crap is, and then it'll give us the refresher from what we've seen in trial. Basket of deplorable garbage says, I guess exalted beings can get Burger King chicken fries at 8 a.m. You guys are so sweet today. I don't know what I did differently. Thank you. I got new earrings. My sister bought me some new earrings for my birthday. Gasp Monkey says, Lori will be sure you reference the crunch in her closing statements. Yeah. My cat's mom says, we can only hope she rests today. All I'm saying is, for whom the bells toll, it tolls for thee. I had a English literature teacher where he used to say, forlorn, the very word is like a bell. I don't know how I remember that after 30 some years, but he says it all the time. It's like, forlorn, the very word is like a bell. I can't believe I remembered that. But thank you, for whom the bell tolls, for saying that. I'm so happy you guys are here today with me too. The judge probably has 62 busted stress balls beneath his bench. Poor dude. Absolutely. There's a couple times he's like, Lord help me. You can see his eyes start to go up. Drop Dead Fred says, I'd love to see Lori's phone records to see who's still speaking to her. And apparently she's getting quite a bit of money for her commissary. So I'd like to know that too. The lipstick today is, I think this is Thrive Cosmetics. Not sponsored, but happily to be sponsored. Thrive Cosmetics Sheer Strength. That's the color. Not sponsored, but should be. Joe Duff Blanton says, I feel like the prosecution built a clean and focused case. I think if we strip away the dramatics of it, they laid it out. I would want more detail, but that's me. Because, my videos are more detailed. So I would want more detail. But I mean, there has to be a limit of what you could put in, or, they have to streamline it. I think Lori muddied it a little bit. But really, there's some good information there. Those texts, that final day was the mic drop, I think, on Wednesday, I think it was, or Thursday. And if I go back, the prosecution said, look, we believe there's sufficient evidence. We have the texts, bringing a handgun, the number of shots, the statements, taking the phone, her motive for money, her motive of affairs. So of the affair. So there's a lot there. There's a lot. Yes, Amanda Baby says 75% of her questions were just filler nonsense. It was bad. At first, she's starting to ask the questions, and then the days go on. Like, what? Did she think she'd be able to think of these things overnight, or she had 5 years to prepare? Laura says, I think she will. Oh, I read that one already. I think I'm a little bit behind. Oh, the Chad Tato emoji is literally Chad because they said he looks like a potato. Do I think her niece will face charges after the next trial? No, sadly, I don't. And I think she should. I think Melanice, as we call her, Melanie Pulowski, aka Melanie Boudreau, previously, should have been charged. They said they couldn't, but I mean, she had motive. I don't know, they didn't have enough on her, but man, she would have had $1 million policy as well from Brandon, and she knew the new address. She was the only one who knew the new address. Also, there was quite a few things in there. I did a series in that as well. Look at the Brandon Boudreau case. I show her discrepancies. Okay, let's check in on the poll. Okay, hang on, guys. I'm going through 7,000 tabs. 712 votes. 92% guilty all the way. 6% I'm not so sure. And no, based on trial, she'll be found not guilty. 2%. And so somebody said, how is Chad participating in this poll? Because of the not guilty. You guys are so cute. Thank you. Okay, now I'm going to catch up because I think I'm way behind in your guys' comments, but we'll get there. The poll is right on my community tab. Feel free to go on there and have your say. If you haven't done so already, here we go. They're just hanging out. Oh, she's wearing her blue today. Is it a baby blue shirt underneath the blue? Her power blue. I still haven't started the audio. I'll write my email here. And thank you for the super chat. Okay, we saw just a little bit of back of Lori's head, and then that's about it.
All right, we're on the record. State of Arizona versus Lori Daybell, CR 2021-001-704. Why don't I have the state announce? And the defendant?
Lori Daybell.
All right, we met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We put drafts on your desk this morning. Last week, let me just pull up that email. Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence. So I added that this morning as well. Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time. Any other record you want to make on mere presence? Oh, yeah. All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm.
Anything else?
The presence of an accomplice.
Okay. And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from Mexican.
Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing two numbers out of randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me, what's 286 is? Whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected. But
All right.
the state redacted out the beginning, the end discussions of hiring. That would be hearsay or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors in all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out. But it's just more or less what was played in during testimony.
Correct.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she testified that it was the full interview?
I don't know. It's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect the record that it was the full interview. So Are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
council checked the FTR, and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the detective at the end about Kylie and victim services. It doesn't include any of that. She's sitting in a room for I don't know how long while Kylie's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Ty Lee said or did or didn't happen, the hearsay parts were the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our exhibit 20, the defense's proposed exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No,
Why not?
your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that.
This is awesome.
Anything else?
That's it.
All right, we're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
That's awesome sauce. That is awesome. The judge is so fed up. He's like, thank God today I don't have to look at her face for too much longer. The judge is so good. He's like, I don't know. You could have crossed and examined her, but it's too late now. She's mad it's not the full interview. And Trina, it's hard to hear, but you could hear Trina say, well, you know, it has Ty Lee in it and victim services and more about Ty Lee. And so Lori's trying to hang on to that so badly because that's all she has is to blame this and blame that. And it's like, you can't admit it because the snippets were already admitted and you can't do the whole thing because there's a significant amount of hearsay in it. And she's still like, so are we keeping them all basically? Like, what is going on? Oh, that's for the jurors. So she went, how long did she go on? She went on for like 7 minutes about this full interview and what it was. And she's holding on to the fact that she asked Detective Inklin if it was a full interview. Well, technically, the detective is right. I did do a full interview with you, Lori. You're just choosing to apply that to the recording. It does. So fed up. I love the name. It says it feels like we're in a loop. We are in a shih tzu storm. It is so good. I love the judge's attitude this morning. He's just like, you know what? I'm over this. I'm over you. Go back to prison. Eat your bologna sandwiches. I don't care. Talk to Chad in your portal potty. Whatever you need to do. Just F off. It was so good. Yep. Gigi says she's going to screw herself over today. Well, this is the beautiful part that I'm here for it. She's already spicy. You hear that snark? It has arrived. And so this afternoon, I'm so excited to see the verbal vomit that's going to come out of her mouth. Now, what do we have next? The jury's going to come in. I missed his last little bit. Nikki says she's loving the attention. She's up there playing the lawyer and she'll be gutted when the attention is gone. The best punishment for that witch is no attention. He has to go out with a bang today. Like, maybe she loses her SHIT and they just have to, they have to stun her just a little bit. Interlocution, nice to see you, says she's so snotty with the judge. He's being patient with her even though he's so over. Today's so good. Just a girl you used to know says, oh, for F's sakes, give it a rest, Lori. She's gonna blow. Your version. Yeah, I love that too. Your version of what happened. He has the good ones today. Why? Like, this is nothing. Maybe he has some more snark behind him. Okay, let me write this down. That was good. Shade from the judge. I've loved the judge the whole time, poker face galore. Today is just extra special. And you can see them button heads. Like, he's just like, this enough. Not today, Lolo. Not today. And we're moving on. The judge just became my favorite with that comment. You could have cross-examined her on that, right? He's like, well, I don't know. You could have cross-examined her on that, but I guess it's too late. Oh, it's so good. It's so good. I feel like this is her bucket list moment. I feel like she's like, this is amazing. I get to be in court and like I play one on TV, a lawyer on TV. Justice for Charles. It's coming today. Yes, please take a moment, click the like button. I appreciate you guys. 2,438 people hanging out today. Brandon's trial is next. That'll be the end of May, starting jury selection. I will be covering that. We'll bring the snark. We'll do some fun things. I don't know. Closing arguments is going to be this afternoon. Oh, wouldn't you love this? Veruca says, just say it, Judge. Tylee is no longer here because of you. So anything about her is hearsay. Yes, the judge is going to be the judge in her next trial, but he said it might be in a different courtroom. And I can't, and something else, he's away on the 16th to the 20th. Yeah. So we need a little break in between that. Nope. Here, I'm going to put closing arguments this afternoon. The judge is racking up the points for the zingers he is bouncing off Lolo's head today. Oh, that was so good. Seeking Justice says, today is extra special. Thank God it's Easter. I'm getting the Ferrero Rocher and tea for closing arguments. He was so mad. Wouldn't this be good? Don't flatter yourself. And you know what's crazy? She just comes and sits there like she's done nothing wrong. I mean, you got to give it to her on that. It's some sort of, I don't want to say special, but it's some, that's a whole other level. The poll I will show you is right here. Robin says, does your board behind you say 144 for Lori? So let me show you my board. This, which I still have to change this, I gotta get my numbers out. But 144 was put because I hit 144,000 before Lori did to gather her 144,000. So we pot-shotted Lori all together in the community. And I started, because it was just, just climbing the numbers, climbing. And then I thought, no, we are 144,000 and we're going to add the rest on the side. So we hit there first before Lori gathered her 144,000. And I still stick to it until we are at the end of trial. I still stick to it. I think I gave you guys the poll link. If not, I'll do that again. Where are we at in it? 887 votes. 93% guilty all the way. 6% I'm not so sure. And 2% she'll be found not guilty. Jeanette says, I was apprehensive about the prosecution being able to handle the defendant, but she did a good job. Yeah. That's about it. Celtic Man says, I watched a retired judge on another podcast. He thinks that Brandon trial won't go to court in his opinion. Well, they're going to trial on what do you think will happen? Lori gives up. I don't think Lori will give up. She's a whole lot of Shih Tzu. John says Lori should get an extra year for flattering herself. I am gathering the people. Lisa Discovers says Lori is busy updating her resume, adding prison pro se consultant. I think you are right. I think you are right, Lisa. Thank you so much for the super chat. I really appreciate it. I think Lori will start doing consultations. I believe Lori will start doing that in prison. 100%. I'm with you. Cheers to that. And you know what? It's going to be interesting that they're going to listen to her because she's like, "Okay, look. Like when a witness comes to the stand and you're guilty, do not address it. Just talk about beverages and just ask, like, bring something up that you really, really touch their heart about, like enchiladas or like a recipe." She's like a TikTok. It's like a TikTok of a creator who tells you the worst. I love TikTok, first of all, but second, she tells the worst kind of advice in the world. Like, just talk about the enchiladas, talk about things like what I wore in like 1998, the type of hair I did, like all that. Just do that so that they can really you play to your strengths and how you look and how they cater to you because that's my love language. It's just my love language, and then you'll win the case. And just make sure that you wear something that gives you power. Like, and the people are going to be like, okay, okay, I'll try that. Because in real life what she's really manipulating with. Down there, screenshot. Lori says, I am having a lot of anxiety lately, so I am here for Linda and a few good laughs. Well, we got to laugh. I did give here's the poll link again if you need it. I should probably put poll link. We're still live on the live stream, so if you're saying court is started, it's not started because it's right on here. I don't even know how you're seeing their back. Okay, but maybe I'm just behind. Lisa discovers a maybe free toilet paper hairdo included. Free with purchase. It's just a free with purchase, okay? My neighbor's sorry. How are you guys seeing this court if I have my court live? I don't know. I don't know. The Gourmet Knitter says the ebook is coming. How to be your own lawyer for your fourth murder conviction. And what probations have you been on? Or what number of probations? Granny Weatherwax says 144 minutes to be found guilty. Oh, that would be good. We should have done a countdown. Thank you for the super chat. This snark has been all this week for me. I'm telling you. Okay, now we got some shadows going on. So here we go. It's starting officially on my channel. He is in a mood today, and I'm here for it. I love it. Let's get into it.
All right, please be seated. The jury is present. Welcome back, members of the jury. Last Wednesday afternoon, the state rested its case, so now I'll turn to the defendant.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions. Are we one? Oh, nope, we got it. Okay. Jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that 1, physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and/or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and/or deadly physical force. However, physical force and/or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, All members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict: count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury.
Okay, so the jury instructions were just read to the jurors. They have 45 minutes that they have to be back at 12:45, which is 45 minutes from now. I'm just going to double check something here. One sec. Okay. So now we wait.
Anything else from the state? defense?
Your Honor, can I move for Exhibit 20 to be admitted for appellate purposes?
Is that your full interview?
Yes.
Any objection? All right, Exhibit 20 would be admitted for appeal purposes. It won't be given to the jury during deliberations. Are you sure it's 20? It's her exhibit.
It is. It's
Defense 20.
no, it's defense 20.
It's defense.
Well,
proposed
it's got
20.
numbered.
Numbered on different ways.
Oh,
It's gonna be 200 and something.
okay. Yeah, give me a second. I'll figure that out.
or your-
I have it as 286. Should we put it on the CD?
Anywhere from 256 to 272. You'll have to figure out which one it is. But we can clarify that. Might have to look at the actual exhibits to determine which one it is.
Yeah.
Ladies and gentlemen, we're gonna ask that you take all of your belongings with you for lunch.
Anything else?
That's all, Your Honor.
So,
Remind me to clarify which one it is when we get back from lunch, but your staff can look at or your team can look at the exhibits.
okay. Now they're on lunch. And then after lunch, we will hear closing arguments from the prosecution, then the defense, and then the prosecution can come back for a final rebuttal, and then we'll see what happens after that. So now, since we have a little bit of time, why don't we pull up? I'm going to pull up Lori's opening statements. And then we can listen to her BS, chit chat about the differences between her between her and her defense that she was doing during the trial. And then we'll see what her closing arguments is. I feel like that's a good kind of thing, don't you think? Okay, 1 sec. I'm going to pull it up. All right. Let's see if I got that. So we're going to play Lori's opening statements, and then we can see her closing arguments and see how that differs and the differences. So here we go.
Ladies and gentlemen of the jury, I have been charged with a crime, a serious crime. And the only question here is, did I commit this crime? Conspiracy. Conspiracy is an agreement between two or more people to commit a crime. Okay, so you see, okay. There has to be an agreement. There has to be a plan. The evidence in this case will show that Charles Vallow and I got married in February 2006. It will show that it was my fourth marriage and Charles' third marriage. At that time, we each had 2 children. I had Colby, who was 9, and Tylee, who was 3. Charles had Cole, who was also 9, and Zach, who was 7. The evidence will show that our family moved from Austin, Texas to Chandler, Arizona in 2009. The evidence will show that Charles and I adopted our great nephew, JJ, who was born in 2012. It will also show that Charles and I were married for over 13 years and were raising 5 children. The evidence will show that I was a licensed cosmetologist and worked as a hairstylist for 20 years while we lived in Austin, Texas. The evidence will show that Charles was a licensed life insurance salesman and worked as an independent contractor, selling life insurance policies and annuities, and owned his own business. The evidence will show that Charles and I purchased life insurance policies early in our marriage, and Charles had them issued to the maximum amount possible to each of us. The evidence will show that Charles was 17 years older than me, and that because of Charles' age and an issue that he had with high blood pressure, the maximum amount of life insurance that could be approved for Charles was $1 million. The maximum amount of life insurance that I could be approved for because of my age and my health was $2 million. The evidence will show that throughout our 13-year marriage, that we always had life insurance policies. When a 10-year policy lapsed, Charles would shop for another company who would approve us for the maximum amount of life insurance. The evidence will show that this was Charles' job. This is what he did. I helped him in this business, and this is what he did. The evidence will show that in 2016, Charles repurchased a new $2 million life insurance policy on me, and he was the sole beneficiary. The evidence will show that Charles and I had a happy marriage for 13 years, that he was, in fact, a baseball player, and that he played high school, college ball, and AAA ball, and that he was, in fact, a left-handed pitcher, a southpaw, they call him, but he was a right-handed batter, as could be attested to by anybody who knew Charles well and his high school baseball coach, Greg Davis. The evidence will show that Tylee was, and in 2014, our family moved from Chandler, Arizona to Kauai, Hawaii. We lived there for 3.5 years and returned to Chandler in 2017. The evidence will show that Tylee was 3 years old when Charles and I got married, and that when she became a teenager, the relationship between Tylee and her stepfather, Charles, became so difficult that Tylee and Charles had to seek a therapist, a family therapist, to stop them from fighting. The evidence will show that together, Charles and Tylee met with this therapist after we moved back to the mainland in 2017. The evidence will show that in April of 2018, Tylee's biological father passed away from a heart attack. And at that time, Charles called Social Security and made an appointment at the Social Security
I'm going to
office.
object to hearsay.
Sustain.
It will show that we did get Social Security for Tylee for her deceased father. And until she was 18 years old, and she was 15 years old at the time. The evidence will show that Charles and Tylee's fighting increased greatly in January of 2019 when Charles and I temporarily separated. The evidence will show that several people witnessed these terrible arguments between Tylee and Charles that increased to physical in 2019. Charles and Tylee had major increasing arguments, 2 in February of 2019, 1 of March in 2019, which was captured on video, 1 in May of 2019, 1 in June of 2019, and then the worst of all in July 2019. The evidence will show that in March of 2019, Charles pulled JJ out of his special school and moved him to Houston, Texas, while we were temporarily separated. Tylee and I then joined Charles and JJ in Texas in April 2019 to reconcile. The evidence will show that JJ was diagnosed with severe autism when he was 3 years old while we lived in Hawaii. The evidence will show that for 2 years, JJ was attending a school in Gilbert, Arizona, a special school for children with autism. It's called Lauren's Life Academy. The evidence will show that in June of 2019, in JJ's best interest, Tylee, JJ, and I moved back to Chandler, Arizona to re-enroll JJ back in Lauren's Life Academy since he had a difficult time with the Houston, Texas schools with no services for his autism. The evidence will show that Charles and I agreed it was in JJ's best interest to be in school where more services were available to him, so Charles and I rented a house here in Chandler. On the day in question, July 11th, 2019, Charles and I were renting 2 houses, one in Houston, Texas, where he mainly resided, and one in Chandler, Arizona, where I resided with our 2 minor children, Tylee and JJ. By this time, our 3 older boys, Colby, Cole, and Zach, were adults and not living at home any longer. The evidence will show that during the months of June and July, that my husband, Charles Vallow, began to send me threatening text messages. These messages were seen by my sister Summer, and that worried her. The evidence will show that Charles insisted on flying into Phoenix on July 10th, as we've heard from the state. The evidence will show that I advised Charles that he could not stay with us at the Chandler house because he could not get along with Tylee, and I did not want them to get into another fight like they had 3 weeks prior. The evidence will show that it was ultimately decided between Charles and I on text messages that he would stay in a hotel because he traveled for business all the time and stayed in hotels all the time, and that I would book it for him since I worked for him and booked all of his travel. The evidence will show that Charles did in fact fly into Phoenix on Wednesday, July 10th, and stayed in the hotel that I booked for him. The evidence will show that Charles paid to fly my brother Adam Cox into Phoenix from Kansas on the same day, Wednesday, July 10th, 2019. The evidence will show that Charles planned to come to our Chandler home and pick up JJ and drive him to school on Thursday morning, July 11th, 2019. The evidence will also show you that Lauren's Life Academy opens its gates at 8:25 a.m. in the morning. And the evidence will show that Charles showed up at our Chandler residence around 7:30 in the rental car I booked for him on the morning of Thursday, July 11th, 2019. The evidence will show that Charles began texting with my brother, Adam Cox, before he entered our residence, and that Charles and Adam were discussing in their text communications that my other brother, Alex Cox, was at the residence. The evidence will show that on the morning of July 11th, that Tylee was asleep in her room and my brother Alex was asleep in the guest room. The evidence will show that when Charles entered the house, only JJ and I were awake and present. The evidence will show that after we put JJ in the rental car, that Charles came back into the residence to receive his phone, leaving JJ in the front seat of the rental car with the engine running. He was 7 years old. The evidence will show that Charles began to scream at me when I refused to hand him his phone. The evidence will show that Charles' screaming woke up Tylee and Alex. The evidence will show that Tylee came out of her room with a bat to protect me, her mother, from her stepfather, Charles Vallow. The evidence will show that Tylee and Charles fought over the bat, and that after a struggle over the bat, Tylee fell onto the ground, and Charles lifted up the bat to hit Tylee with the bat. The evidence will show that Alex then intervened to protect Tylee from being hit with the bat. He did not have a gun. He was not wearing a shirt. He was pulling up his jeans because he just woke up and came into the room where he heard the screaming. The evidence will show that Alex and Charles got into a physical struggle for the bat and fell onto the ground. The evidence will show that Tylee, who was on the ground, was lifted up by me and sent outside to get away from the struggle and to protect JJ, who was still in the running car, in the rental car in the driveway. The evidence will show that after the struggle on the ground between Charles and Alex, that Charles prevailed with the bat and began to come towards me with the bat as I ran away from him into the kitchen. The evidence will show that at some point while I was running away from Charles, who was chasing me with the bat, that Alex apparently retrieved his gun. The evidence will show that I ran outside to the children and that Alex shot Charles in self-defense. The evidence will show that Tylee and I had both run outside without shoes. The evidence will show that JJ was still in the front seat of the rental car with the engine running and struggling to get out of the car. Tylee was trying to keep him in. The evidence will show that Tylee and I got into the rental car with JJ and drove away. The evidence will show you that I drove the children away from the residence towards JJ's school. Can I grab a tissue?
Yep.
The evidence will show that I drove the children through the Burger King drive-thru that Charles had promised JJ. The evidence will show that we continued to drive towards JJ's school and that the gate was not yet open at JJ's school. So we drove a block west of the school to a Walgreens where I ran in to purchase flip-flops for Tylee and myself so that we could walk JJ into school on the hot pavement. The evidence will show that Tylee and I returned directly to our residence where we met with police in our driveway. The evidence will show that we were spoken to by the Chandler police officers. And the evidence will show that Tylee and I were told by the Chandler police detectives that Charles had passed away. The evidence will show that we were put into a police van and driven to the Chandler Police Department. The evidence will show that Alex was taken by police in a police car to the Chandler Police Department, and that we were all three separated into interrogation rooms and we were each interviewed. The evidence will show that next, Tylee and I were brought back together into a room at the Chandler Police Department and were introduced to a victim's advocate who was very kind to us. The evidence will show that after speaking to the victim's advocate, that Tylee, Alex, and myself were put back into the police van and driven back to our residence. We were directed by the Chandler detectives to take the rental car and return later to the residence after we picked up JJ from school. The evidence will show that we did as instructed by the Chandler detectives. The evidence will show that we drove to Alex's residence where we attended to the wound on the back of his head. The evidence will show that Alex was then contacted by the Chandler detectives to return to the residence so that Alex could walk them through the events that occurred with the detectives at the residence. The evidence will show that Alex, Tylee, and I did return to the residence as instructed. And the evidence will show that Alex entered into the residence with Detective Moffett, but that Tylee and I were met by Detective Inkland in the front yard. The evidence will show that at the time, Detective Inkland asked Tylee and myself if we had Charles' cell phone. Tylee retrieved Charles' cell phone from the rental car and gave it to Detective Inkland at 3:11 p.m. on July 11th, 2019. And at that time, Charles' phone was placed in the custody of Chandler Police detectives. The evidence will show that Detective Inkland asked us if we knew the passcode on Charles' phone, which Tylee proceeded to give to Detective Inkland. The evidence will show that Tylee and I left the residence to pick up JJ from school, while Alex remained at the residence with the detectives. The evidence will show that by the time Tylee, JJ, and I returned to the residence, that all police, EMS, CSI, and detectives were gone from the residence and only Alex remained. The evidence will show that the next day, I contacted Chandler Police to inform them that Charles' belongings were still at the hotel. I asked the detective if I should go get them, and I was told that they would take care of it. The evidence will show that I asked the detectives, what should we do next? And they directed us that they would contact us in about 3 weeks after their supervisor passed off their reports, and Alex could go to the police station and retrieve his gun. The evidence will show that the last thing I heard from Chandler Police Department until June of 2021, 2 years later, when I received a grand jury indictment from them for this alleged crime. The evidence will show that Chandler Police treated this incident as self-defense.
And object to that.
The objection sustained. The jury should disregard that last statement.
The evidence will show you that my brother, Alex Cox, passed away on December 12th, 2019, almost exactly 5 months to the day after Charles, my husband, passed away. The evidence will show that Alex passed away from a blood clot in his lung.
Objection again.
I'll sustain the objection. It's not relevant for this matter.
The evidence will show you that I am the only person being charged with this crime.
I would object to the relevance of that.
Sustained.
As the state has mentioned, they're alleging that insurance money was my motive. Social Security was my motive. Spouses having insurance policies is not a crime. Collecting Social Security is not a crime. Self-defense is not a crime. A family tragedy is not a crime. It's a tragedy. Thank you.
All right, the state can.
And then the little final, thank you. Yeah, they're all dead. You're the only person left. So, yeah. And Social Security is a crime, Lori, when you did that. You were collecting, and you weren't supposed to be collecting, and you killed the children, and you killed your fourth husband. But notice how in the opening statements, it's not my husband, it's Charles. But then throughout when the witnesses come out, it's my husband. My husband. So the evidence will show a cajillion times. She goes through this, and I wrote everything down, okay? She talks about being married. Let's just hierarchy this thing, this mofo. She's been married to Charles, our great nephew, meaning JJ. She talked about what they did for a living, that there was insurance, that Charles is 17 years older and has blood pressure, and her max was 2 million and his max was 1 million. They had a happy marriage, she said. He's a ball player. They moved from Kauai. It was difficult with Tylee and Charles, and increased physical violence in 2019, March, May, June, and July, worst of all. She talked about Joseph and Tylee collecting benefits. JJ got pulled from school didn't mention he was abandoned for 66 days or however many days it was of Lori, around 70. This is interesting. Where she said, special services, which he was going to a special school, and that school is quite amazing. Lauren's Life Academy. But then she's talking about how he moved back to Texas and had no services. Well, Lori, you took him to Idaho and you put him in a regular school with no services. So there's that. Then she says she's getting threatening messages. But she didn't want him to stay at the house because they were fighting, and so she worked for him, so she did all the planning. Then her brother came in, and Charles wanted to pick him up on July 11th. 8:25 the school opened, she said. 7:30 Charles came, and he came in the rental car that she booked for him. Then Adam texted, but she didn't say how Lori and Chad had deleted texts that day, of course. And Charles was screaming, is what she's claiming in these opening statements, and woke up Tylee and JJ, and that Alex was just protecting her. Don't forget, Alex is her knight in shining armor. And she was crying at this point. This is when the crocodile tears came. And that Alex intervened from Tylee being hit by the bat. And then she says Charles came at her with the bat, but she was running around with Charles's phone. And Alex went and got a gun, and she just ran outside with the children. This is interesting. She said no shoes. But this is where she said that this makes no sense, and she's reading, okay? She said JJ was struggling to get out of the car, and Tylee was trying to keep him in. You see the discrepancy there? Discrepancy. Then she grabs a tissue. She probably realized what she said. She went to Burger King, went to JJ's school, and the gate wasn't open, so she just went a block west to go get herself some shoes. We showed a few days ago that she was actually wearing something coming into the Walgreens. I don't know why they didn't out that. Then she said she met the police. This was interesting. She said the interrogation rooms, they went together, and then she got a victim's advocate and just lightly said, who was very kind. Like, that is the one sentence out of all of it that just like, this does not fit for what you're saying. Then my pen died because I'm so full, sick of her I'm sick of her bull Shih Tzu. We don't want any bull Shih Tzu here today. And she said she did as instructed. They drove to Alex's residence to take care of the wound. They returned to the house. Alex had to do a walkthrough. Detective Inklin talked about Charles' phone and wanted it at 3:11 from Tylee. They picked up from JJ from school. There was detectives everywhere and CSI, she said. And she just wanted to know, what should we do next? Oh, Lori, you're so noble. What should we do next? Meanwhile, she's making phone calls. Chad's calling the mortuary. She's having a pool party. So what time did the officers leave? Anyways, she is claiming the self-defense, and she said something about self-defense. The evidence will show it was self-defense. The prosecution objected. And then her interesting line of Alex passed away. Alex passed away almost 5 months to the day. And I find that so interesting only because I did a video about all their dates and how there's a pattern to the women's dates that they were killed and the men's date that they were killed. And there was all a factor. It was all a pattern. And Alex is also part of that pattern, even though he died of natural causes. And then she said, I'm the only one charged for this. And she said, Social Security is not a crime. Self-defense is not a crime. It was a family tragedy. So that's her BS in a nutshell. Now, I like that we were able to show this right now. I think it's a good refresher because in 15 minutes, they're going to come back and opening statements are going to begin. Probably within that 15 minute after that, but 15 minutes, they're to come back from lunch, okay? So I like that we did the refresher because now we're going to see what our closing arguments are. Now, out of all of this, okay, let's talk about the evidence. Out of all of this, out of everything she said, insurance is relevant, but they were married is relevant. Interestingly, she said right-handed batter, but he's a southpaw, but Kay said no, no, no. Let's see what else. JJ being pulled from school doesn't, to me, is irrelevant. Social Security. About Lori working for him, just irrelevant. Let me see. Well, she went on for how long? And she talks about the bat, but that's full of you know what. Alex isn't just going to bring his gun over unless he was expecting a fight. I don't know. You just bring your gun over to your sister's house. And I did a video on that, and where he put himself, I think it was Tylee's room he stayed in. It was the front window, so he could see Charles coming. So I did that way long ago. I think the children were just found. It was a month after I was going after the Charles case because something wasn't. Now, back then, we didn't know what was going on. We just knew, like, the kids are missing. They were just being found, like, all this stuff, right? So we don't know what we know now. We were wondering what the heck's going on. Yeah, wow. So that's a load of baloney. Alex said he brought it to do some shooting with Lori the next day. Yeah, he's a real... They're all so full of Shih Tzu. Her evidence didn't show anything, so the prosecutor goes first. Oh yes, the important detail that she's a hairdresser. Don't care, Lori. Silent One says, Alex brought a 45 and 3 magazines to a house with a 7-year-old autistic child. The gun was in a case, a duffel bag, his clothes in a plastic bag. Yeah, she does lie all the time. That's right. But the problem is Lori didn't have to show or prove anything. The state is the one that has the burden, 100%. But Lori's whole statement is about how the evidence is going to show. Well, we see what the evidence shows, Lori. The evidence shows you're laughing your ass off on camera and talking about, did you see the woman in a nightgown on the street? Who cares? And the evidence shows you're laughing all the way to the police station, never called 911, had deleted text between you and Chad, who he should be charged as well. I did a coded message, coded note. I still stand by it. Go check it out. And that showed that she wanted him to come the week before. And I don't know what happened with that. I would have loved to have seen the other text that wasn't ever pulled because it's important. And you didn't call 911, but you went to the store. You perjured yourself saying you didn't have shoes, but you did, as shown on camera. Don't know why that wasn't pulled up because you know what? That's perjury. And she did bring it up in court, so I think that is relevant. It just goes on and on. So let's see what you're all about. And Andrea says, and the state proved their burden, in my opinion. If I ever need a lawyer, I'm calling Linda. My sister says that sometimes. She's like, it's too bad you weren't a lawyer. I'd be spicy in court. I'm sure I would be spicy. Okay, let me see if I just got to bring this back in now. Let's check in on the poll. 1.2, so 1,200 votes, 90% guilty all the way, 6% I'm not sure, and no, based on trial, she will not be found guilty. I'll pull some more comments maybe from there as well, but I just want to cue this up. So we don't miss it. Oh, you guys are doing the mug shot. You're talking about the mug shots. Let me see if I have it. Oh, I have Chad Tato. Let's see what else I have from the case just queued up in here. Lori's smirk, or Lori's look. Chad's dumb mug. More of Lori and her jovial attitude. Lori again, smiling. Oh, here it is. There's her Pippi Longstocking face and hair. And her looking like she's reincarnated. Another mugshot of Lori. And wow. Another one. We just got to get all the dumb. I enjoy giving her the dumb looks. This is a meme that I was sent. And this is the latest of the Shih Tzu Barbie who's not nonchalant. So we have a plethora of Lori's BS. I like showing how ugly she looks. You got to do it. Let me see how I get this off now. Okay, here we go. And then, yeah, the smug shots. The poll is on my post on my channel. Feel free to leave a comment. And, oh, I should put poll. There was a comment of the pool party once, I think, this week, but I think it was by one of the it was a detective. I'd have to look again. The closing arguments should be good. I can't wait to hear what Lori says. Yeah, I hope she loses it. She was spicy this morning. She was spicy, so bring it. I know they do look alike. You got to see that. Jesus told Lori in the porta potty that the evidence will show that there are no flip-flops left alive to corroborate or deny Lolly Time Shih Tzu enchiladas. And don't forget her Lolly Time workouts at jail now and her special new consultations where she's teaching others how to be a fake lawyer in court. Shih Tzu Sharpay. Keep Shih Tzu Barbie up until court resumes. Nice to see you, Jody. My Shih Tzu mix is offended. 99 Pink Balloon says the YouTube videos her son makes are worth your time. Yeah, it's not that I don't want to see them. Yeah. I used to watch a few when he first started. But then, life gets busy. How much longer? 2 more minutes that they're supposed to, so I guess 5 minutes after that. So 7 minutes that they'll start. Laura says, scary thought, how many women believe her and look up to her? Oh, I don't know. Good question. Good question. Oh, thank you, James. That's very sweet. Thank you. Susan says, I predict the jury will return a verdict between 7 to 8 p.m. Eastern. Wouldn't it be great if it was 144 minutes? Oh, speaking of, one of the viewers last week, we were talking about the dates for Brandon Boudreau's trial. And Lori really, 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 really wanted it on May 11th. And that was her deadline for the speedy trial. But the judge is like, you can't do 2 trials in one. You can't book that. So too bad, so sad. I considered it, but you can't do that. So we're going to do it end of May. It's like 2 weeks later. And then we looked up what May 11th is. One of the viewers did, and it's Mother's Day. So of course she wanted to start on there so she can start off with a bang and go and be there for Mother's Day. At this point, she's probably hoping that she gets caught on all kinds of things so she can be in court. Closing arguments should be in the next 10 minutes. Hopefully. This will be a 30-minute delay. Shouldn't it be a 5-minute delay? Yeah, little Gannon. Gannon's mom and I share the same birthday. And every year I wish her a happy birthday. We're like birthday sisters. Oh, 30 delay until the, well, that's weird. Maybe I just don't remember from this morning. Yeah, well, good thing she's not going to be on May 11th, so still a 30-minute delay. Okay, so we're going to keep talking then. So for those of you just joining, we just played the opening statements of Lori and how most of it was BS, and she's saying the evidence will show, but it really is like a big diversion, pretty much. But no surprise. And the interesting thing is she was talking about Charles, and they were 17 years older, and she brought up that Charles had to have blood pressure medicine. She also tried to say in trial that he was taking testosterone and HGH, which most men that I've met, a lot of men take testosterone, so whatever, and just for their own levels. So Lori's an idiot, but we know that. Okay, no, the verdict is a 5-minute delay. Okay, verdict is 5-minute delay, but we're in a half an hour. So if we have time, do you want me to do more questions, or would you like me to play something different? Or, well, we already saw Lori's opening statements. I love Landon. She's so good. Well, I'm so glad you're enjoying the channel. Now, for those of you who are wondering, why the heck am I not getting notifications? What's going on? The trick is if you just watch a few of my videos, watch it in its entirety, and watch a few of my videos, that it'll most likely start coming on your feed. So if you enjoy this and you like watching trials, make sure to do that. And then also, because the end of May, we're doing Brandon Boudreau's trial. I'll be doing the Idaho 4, hopefully. And whenever that is going to be, it says August, but sometimes it gets pushed back. Maybe it won't. That's going to be 3 months worth. So you guys, we're all going to be in it for 3 months. And what else? Yeah, and then also watch my regular stuff, and then with guests. So if you have any info of how I can, like, if we could streamline this, because I'm just a one-person show. I do not have an editor anymore, even though I love Marina. I love you, Marina, if you're watching. I don't have anyone right now. So if you have info on some of the people to interview, like, oh, we have Colby's information, so to speak, to reach out to him or whatever. If you want to do that and send it to me in email to save me some few minutes of time, I would be super appreciative, and then I can put everything together. I'm so glad to be back. Murder of Crows says, how many times did Lori say the evidence will show? I lost count at 144,000. No kidding. Okay, you did not miss closing arguments. It will be coming up in apparently the next 20 minutes. Oh, I pulled up Shiloh's thing again. So I'm going to confess I made green chili chicken enchiladas in honor of Lori going to be found guilty. And I used canned chicken for the first time that my family didn't get my humor. I love that you did that so much. Okay, I did have, now it's not showing. Oh yeah, there we go. Okay, so people are saying that the judge brought the jury in. So I don't know why it's not showing. The evidence will show said 75 times. Now, Lori said that the closing arguments are going to be less than that of an hour. So wondering what she had to fluff up. Because at first, when she first started trial, these questions were like, "Oh my God, this trial is going to take 10 weeks." Seeking Justice is not bragging, but I'm ready for closing. Yorkshire Ferrero Rocher's crisps and popcorn. Is crisps chips? She had to fluff up her portal. So right now, technically, they'll be walking into the court. They had to be there 7 minutes ago from lunch. But we have a delay still, apparently. So, okay, chips equals crisps. Tracy says, Linda makes these awful things that happen bearable to get through. We've got the absolute best family right here. We laugh, we cry, but we do it together. This is my happy, safe place. I'm so glad that you guys feel it's a safe place to be. You guys created it too. Okay, I want to go to Greece. It's 11 p.m. here in Greece. I just actually made popcorn, my midnight snack, I guess. I want to go to Greece. I saw a beautiful place in Ios, Greece that is like, oh my gosh, I got to go there. Misbehave says Lori will, nice to see you again. Lori will do a song and dance show for sure. When I do a video, so you guys know, not live stream, just a regular video, I go in the comments and I try and comment as much as possible when you comment. And I do read. And it's so cool that I recognize people's names and get to know you guys. Even though I've never met you guys, but I haven't. Okay, so if Trina's already in her closing argument, that means in 20 minutes it'll be on here and we can watch it together. I hope she loses it, her SHIT, her Shih Tzu. I really do. Lose your Shih Tzu. Lose your Shih Tzu. I'm surprised she didn't put her hair back, but maybe she'll do her hairdo when she's convicted. Yeah, for sentencing. Maybe for sentencing. Yeah, heck yeah, I want to go to Greece. That's on my list. Maybe I just do a yeah, let's do a crime trip to Greece. Let's go. I'll just travel for a year. My son can learn as we go. We just like, you can learn this, you can learn that. I'll just travel. We'll do Airbnbs. I'll come stay with you guys. It is demonic the way she killed her children. Oh my gosh. Everybody's going to Greece. I want to go. I literally looked up Greece the other day going, "Oh, wow, look at the view. Look at this hotel. It looked amazing." Greece is too hot for a woman my age. Hot flash. I have hot flashes too. What are you talking about? We'll just carry a little van walking around. Okay, barely we're planning a trip to Greece. We are waiting for closing arguments, and it should be in 20 minutes now. Not even 19 minutes. Meanwhile, Mattel's real Barbie's like, WTF, no thank you. Oh, okay. Nate Eaton said Colby and Kelsey are in the courtroom sitting next to Kay Woodcock. Awesome. Man, this is amazing. Oh, you guys are in Greece. I want to go. I'm coming over there. Samantha says, I'm a dog groomer and I've seen an uptick of Shih Tzus coming in since trial. Coincidence? And you can thank you, Samantha. They come in and you're like, oh, come on. Like, do I have to think of Lori every time the Shih Tzu comes in? Have you seen those videos where they actually dye the hair of the dogs and they become like Tigger and a unicorn? If that happens, I want somebody to do Lori up. Like the poor dog would be looking like Lori, but just once, like orange for the coat for what do you call it? Not army, her jail wear, prison uniform, whatever. I'm getting tired already. It's only been 2.5 hours. Okay, so 17 more minutes. It should be happening. Thank you, Samantha. If I haven't said thank you already, thanks for the super chat. That helps a lot. Come to Kelowna. I do every year go to Kelowna. We'll see if I'm going to Kelowna again this year. It gets expensive there. Like ridiculous in summertime. Oh, you thought it'd be a lot more in Santorini. I wanted to go there too. Well, I'll go together. Claudia says, I cannot wait for the jury to hear the full story. No kidding. Where is Kelowna? It is in Western Canada. It is like a little mini California wine country. And there's like 150 wineries or so, might be even more now in that area. It's beautiful. It's by water. And I love it there. And it doesn't snow like it does here. It snowed this morning. It's April 21st. It's been snowing. And it snows from like September to May. May long weekend we get snow. Then we get June, July, August of semi-good weather. And then we start all over again. I don't know why I'm here. I really don't. Kelowna, you could wear shorts from like March to October. Mary Claire says jealous it's 90 here. I want it to be 90 here. Yesterday it was 34 your guys' weather. Yeah. Canada is beautiful. Okay, so we have about 14 minutes left. PJ Cat says, the reason for Shih Tzu hair is that it pulls up your forehead and is a jail facelift. It was real high the other day. Oh, in Camrose. Nice. Not too far from here. Oh, my lip color is, I did a different one, I think just a little bit ago, but it's by Thrive Cosmetics. Sheer Strength. Look at that. Sheer Strength. Low. Oh, yes, if you could take a moment to like the button, subscribe, share, all that, that'd be wonderful, and I super appreciate it. Hello from Calgary from me too. Are we all part of the 144,000 of It's a Crime? So we have, 13 minutes left, so it's great. Kelowna is amazing. Okay, so closing arguments, we have Lori. No, we have prosecution goes first. They'll summarize everything and review the evidence and tell the jury why they should return a guilty verdict. And then the defense goes next, which is Shih Tzu Barbie, Lori, Daybell. And then she'll respond to the prosecution's case, which we don't think that's going to happen. She's going to be divert whatever she wants. And then we have the prosecution that gets the final word. They carry the burden of proof. So they're allowed to do a rebuttal or final closing. And then it'll address the defense's argument, which should be interesting. And we want to see Lori lose her absolute marbles on there. Maybe just a little shock. Just a little bit. How many do you think is her family? It's like just a little bit. So they are currently in session, but we have a 30-minute delay. So we have 11 more minutes, which is great. Oh, Grand Prairie, yes. GP. Just a little bit of a zap. Just a little bit. Like 1.44. Apparently, the 5-minute delay is for the verdict. But we're on a 30-minute delay. So you can see to my left, or to your right, guys, is right. This is live. The court proceeding thing is live. So as soon as that goes on, I will minimize myself to like that, and then we can watch together forever. It's been so good to watch this with you guys. I can't even watch it anymore. Like watch a trial without you guys. It's like this different. I don't know what's going on with my coughing today. I know time is taking a lot. Allison says nobody covers cases like Linda. You're very sweet. Thank you. We enjoy your sassy behavior. Thank you. I can't help it. It's just part of me. It's the part of the snark, and it just, Letitia, Lori, Barry Morphew, Corey Richens. If Letitia and Lori had a baby, it'd be Corey. Oh, mommy of Huskies says, I've been referring to her as Hoary Shallow Dumbbell for years. Thank you for covering this, Linda. Thank you. And thank you for the super chat. You're welcome that I covered it. I love doing this with you guys. Sharon says, Canada is on my bucket list. I need suggestions. Definitely British Columbia has to be on the list. Alberta, British Columbia, yes. Okay, everybody's saying it's on now, but you see how there's a beautiful little thing on my right here, right there. That is not showing live. It is showing live, but it's not on yet. So it doesn't matter what other channels have on right now. It's right here. So we have like 6 more minutes, which is okay. It's okay. I don't need to refresh, because if I refresh, then it's definitely live. So what happens is I can tell if it's live or not, because there's a little red thing. So we're good, guys. We're good. And if I go to a different channel now and it's started, then we're going to miss it. And then other people are going to get mad, right? So we are at 2:08 my time, 1:08 Arizona time. Yes, Banff and Jasper. Jasper did have a fire though, but Banff, Field, BC, Kelowna's beautiful, Victoria. Everybody needs to do a little woosah. Yeah. Calgary girl here too. But BC girl growing up. I love hanging out with you guys too. Okay, so we have like 6 more minutes. We're good. We're okay. It's gonna be okay. Everybody take a deep breath in. We can do lolly time aerobics and breathe out. Woosah. Breathe it in. Everything's be okay. I don't care if it's on another channel. And breathe out. Woosah. It's gonna be on here soon. Okay. Closing arguments coming up very quickly. Let's just put this up here. There. Lolly time aerobics. Yeah, just a little bit. A deep cleansing breath. Imagine Lolo going to prison in Arizona. Imagine her standing up and losing her SHI Shih Tzu. And imagine Chad in his portal potty summoning Lori. I don't know what else. Perhaps he's constipated right now and he's thinking about Lori. Okay? And then Lori, just think about her coming up and verbal vomiting all over the courtroom today and the judge getting sick of her Shih Tzu. Okay? Okay. Everybody get a snack. Roby loves making popcorn. Doesn't matter who else is streaming right now. The closing arguments, you guys are here. I appreciate you. You're supporting me. Crown Royal would like to see her get shocked. Okay, wait, I'll do my radio voice. Everybody calm down. Take a deep breath in. And release. Today we're doing a Shih Tzu hair tutorial on how to be a little bit more uptight in court. We have 2 more minutes. To my left, you see a live stream with Nate Eaton of East Idaho News. As soon as that plays, Linda will play it. Center, find your center to deal with Lori and her closing arguments. Shih Tzu ASMR, get ready with me. First, we're gonna grab some purple highlighter and we're just gonna put it on there. I don't know. Everybody's just getting so uptight. It's just like, we gotta chill out. Let's just chill out. You like the elevator voice? It's like, today we are going to be talking about Lori Daybell. Or there's people who do the vocal fry. Today we're going to do like the Lori Daybell case and like, so anyway. It's because I'm hungry. I don't even have anything like a Jolly Rancher. We need some Jolly Rancher tutorial. No, Lori's closing is coming up in 1 minute. 1 minute. Let's do the countdown. 2 minutes for the portal to Lolo. Please fasten your seatbelts. The Lolo train is now going for takeoff. Please fasten your seatbelts. Oh, you don't like that? Court's going to be starting. Oh, yes. A non-chelada recipe while we're waiting. You take the main layer of BS and you smother it with some green zombie names, and then you make up a lot of sprinkle of numbers and conspiracy. You have to delete the text for the texture. I don't know what I'm talking about. I don't know. I want to get Lori's crap over with too. Should be any minute now. I got it. Now, see, we have the seal here. It's going to start very soon on my stream. It'll be okay. Count out 144,000 granules of salt. Okay. Do you think Lori's going to be doing her my husband? How many husbands does she put in there? Will she? I'm sure she'll bringing up Tylee. I don't know. Maybe at this point she's gonna have to unbutton some buttons and do some things to convince the jury. I don't know. Here we go. Look, it's on, you guys.
That's fine. All right, we'll go on the record. State of Arizona versus Lori Daybell, CR 2021-001704. Before our break this morning, the defendant moved to have an exhibit admitted for appeal purposes only. That exhibit number, the correct number, I believe, is 269.
That's what I understand, Your Honor.
All right, so it's ordered that 269 would be admitted for appeal purposes. It won't go back to the jury during their deliberations. Go ahead and get the jury lined up, I guess.
I agree. Let's see Lori make a spectacle of herself. I agree. I concur. Could you imagine me interviewing her? That would be priceless. What kind of things would you want me to ask her or say to her? Liz in Texas says my payment for the pre-closing meditating. Thank you. You like that? Woosah. Okay, we're rising. Sorry, guys. I don't know what's going on with my coughing.
All right, the jury is now present. Please be seated. This is time set for closing arguments. The state can proceed with its closing argument.
July 18th of 2019, just 7 days after this defendant and her co-conspirator Alex Cox shot and killed Charles. This defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to? Later that day, after she spoke with the life insurance company, he sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money. But Lori Vallow's plan to kill Charles wasn't just known by her lover, Chad Daybell, and her accomplice and co-conspirator, Alex Cox. It was also known by her brother, Adam. Adam told us that he knew about Lori's beliefs. He knew what she had been saying about Charles's concerns for himself. And he told us that he knew about this plan for an intervention to talk to a stakeholder. That morning of July 11th, when Charles arrived at Lori's house, as she knew he would, he texted Adam and said, "Al is here." Adam texted back, "They are planning something." He knew. And 3 days later on Saturday, when Adam finally learned, when his friend Googled Charles, that he had been shot and killed by Alex, Adam told us he went back and talked to his mother and he confronted her about this. And he told his mother, Lori and Alex conspired to kill Charles. He knew, and he was right. Lori's ex-friend, Christina Atwood, she told you about that very uncomfortable dinner on June 9th, a month before the murder, where Alex Cox was talking about just wanting to kill Charles. He said this multiple times, and this defendant didn't care. In fact, she talked about how she had been drugging Charles. Christina told you she was so disturbed by this, she actually went and saw Lori the next day, June 10th, and told her, if something happens to Charles, I'm going to have to go to the police. Christina knew. She was right. And Nancy Jo Hancock, now she had just met Charles a few days before, and they had talked and texted and had been on the phone for hours, you heard. Charles had told her all about Lori, the things she was saying, the things she was doing. She told you that she knew that Charles was concerned for his own safety. And she understood the motive. She told Charles the night before, you probably should just tell Lori that you've changed the beneficiary, that she's no longer going to get that money. Nancy Jo knew, and she was right. Lori Vallow wanted the $1 million, and she wanted Chad Daybell. And she and Alex used that twisted religious beliefs they had so that they could kill the evil, possessed Charles and be like Nephi. The evidence that has been presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit first-degree murder. So I want to split up my closing into 3 sections. First, I'm going to talk to you about the timeline and the motives in this case and the evidence that supports those. Second, I want to talk to you about the jury instructions and the evidence that's been presented to you in court. I'll remind you that anything the defendant said in her opening was not presented at trial through a witness or through an exhibit, and it is not evidence. Using the evidence that has been presented and admitted at trial, the state will show you how, again, the defendant is guilty beyond a reasonable doubt of this crime. And finally, I'm going to talk to you about those justification defenses, the excuses and the reasons why the defendant would like you to believe that they had a valid basis for shooting and killing Charles on July 11th. And we'll talk about how, in fact, there is no justification for what they happened. What happened that morning was a first-degree premeditated execution of Charles Vallow. So let's go through the evidence. The timeline really starts, and we know it goes back much further than this, but the big change occurs on June 29th or 30th, when you learned that Charles Vallow learned about these KK Walker emails. He learned about that affair with Chad. Now he knows Lori is cheating on him. We know that he contacted Chad Daybell about it. He contacted Chad's wife about this. He told Adam about it, and he told the defendant about it. So everyone knew that Charles now knew this. July 9th is now the first time that Charles is going to be coming back to Arizona. We know from the time he learned about that affair, he hadn't been back until this planned visit to see his son, JJ. We know at 1:13 p.m., Charles texts Adam and books him a flight for the next day. At 1:21, we know that Adam is contacting Alex. And they talk for 20 minutes. And Alex lets Adam know, sure, you can stay with me. Of course, Alex doesn't know the plan yet, the mission. Lori then starts talking to Chad Daybell. We know that she knows about this intervention. She knows about Adam coming. And we know this because, again, of her text messages. We see Lori then starting to round up the troops. Why does she do this? Because she wants to ensure that on July 11th, it is Charles and only Charles coming to the house and not the intervention of Adam or Brandon or Zach coming over to help him. So she has Melanie. Tells her she can't go to this wedding. She has to stay here. It's coming to a head. This week will change everything. Call me. Then we have July 9th, the text messages with Alex. She tells him, so the plot thickens, call me when you can. He doesn't call her initially. So she sends him another message, this one really letting him know. She specifically tells him, I'm going to need you to stay close to me the next couple days. Mel too, she can't go to Utah. She's got a job. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone. She talks, I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. And then what happens? This gets Alex to call, and they talk for almost an hour. An hour planning how they're going to stop the intervention, how they're going to be like Nephi. As we get to the 10th of July, and we continue through this timeline, we see Lori again talking religiously with Chad, 149 minutes that morning. She's also texting Melanie Boudreau, Melanie B, telling her that it's important for the mission, for Melanie to help her by keeping Brandon distracted. And we saw those messages where Melanie says she'll pretend to be sick. We know that on the 10th, Adam arrives in Phoenix. And now we have Summer helping the defendant, letting her know what is going on with Adam and Zach. Everyone is covered to ensure that Charles will be alone on the 11th. We have the continuing talks with Chad, her soon-to-be husband. As we get into the 10th in the afternoon, we know that per their agreement, Adam calls his brother Alex. Hey, I'm here. Brother doesn't answer. He sends him a text. I'm here. No response. Why? Because the night before, his sister Lori told him, we have a mission. We must be like Nephi. Charles is coming into town. You must stay at my house the night of the 10th so you can be here the morning of the 11th. We also know that Summer gave Lori an out. Hey, you can stay at my house. No one will know where you are. We're going to be out of town. You can hang out here. Lori doesn't take her up on that. She has a mission to do. As the night grows on the 10th, Adam continues to try to reach his brother Alex. Again, no response. And by 45 or so minutes after that last text by Adam, we know Alex is already at Lori's house. He's there with his gun and a garbage bag of some underwear. Why? That gun is important. A loaded weapon, 2 extra magazines of ammunition with him. He is ready for his mission. And again, Summer is updating her, telling Lori that Zach and Adam are still at her house. They're going to go stay at Mimi's. And she even tells him that Adam is still waiting for Alex to get back to him. Still, he doesn't understand. Why isn't my brother responding to me? I was supposed to stay there. And again, what does Adam bring over? Gun and a garbage bag of clothes. That's all he needs to be part of the mission. When we get to July 11th, we still have Lori talking with Chad. We see those text messages going back between them. And then we start learning from the GPS from Charles Vallow's phone as he arrives. 7:35 a.m., he arrives at 5531 South Four Peaks. That's where we have at 7:36, Adam texting Charles. They are planning something. There is no reason why Alex should be there. And that explains why Alex wasn't responding to me and didn't let me stay there. We see that last outgoing text message by Charles Vallow at 7:37. And in fact, what we see is at 7:37 and 12 seconds, Charles sends out his last outgoing message. And at 7:37 and 29 seconds, there's an incoming message from Adam. It's not read until 12:13 p.m. What becomes important here is in this timeline, how long is Charles at the residence here? You hear in her interview how she says it's so fast. Charles comes inside. He's angry. He's jerky. And she tells him, take JJ. Go get him Burger King. They get JJ out to the car. And then she holds onto the phone. And this argument erupts, and it's just so fast. But what we know is it's actually 12 minutes long. This is not a fast incident. In this 12 minutes, Lori Vallow and her brother Alex Cox are doing their mission, and they are being like Nephi. We know at 7:49, it's over. Lori has left in Charles Vallow's car with his phone and JJ and Tylee. We know that there are 2 phone calls between Alex and this defendant after she leaves. As Charles is laying, dying or dead on the floor, 7:52, 8:06, they talk. 47 minutes passes before Alex calls 911. 47 minutes to stage the scene. The police are advised when they arrive that the shooting just occurred and that CPR was given. Why is that important? Because you heard even during the interviews, the police were trying to figure out this timeline. Didn't make sense. At 8:48, almost an hour later, Lori Vallow returns. And then we see that around 9:40, she is being interviewed at the Family Advocacy Center. We know that Lori Vallow has Charles's phone that entire afternoon. You saw the PowerPoint from Detective Werther showing that her phone by about 12:36 is already her phone, Alex's phone, and Charles's phone are all in the area of Alex's house out in Sandham. You see on her records that she again calls Chad Daybell. We see that Detective Enclan calls her and leaves her a message. They don't leave immediately because what do we know? We know at 2:13, Alex is taking photos of Adam's or flight reservations from Charles's phone. Not screenshots, but photos of the phone. At 2:18, Lori Vallow, who has not told Charles's kids, his family about his murder, is calling the mortuary. A little bit after that, they still haven't left. She's calling Chad again. And then by 3:11, we know that Charles's phone, through the GPS data, is back at 5531 South Four Peaks. And when asked about it, the defendant entirely handed over and provide the PIN. They have no problem on how to get into it. They've already looked through it. They don't need it anymore. That evening, Lori and Chad are talking all night. You can look through the exhibits and see the multiple calls of them discussing. These aren't calls to Charles's family. They're not calls to his kids. They're talking with her lover, her soon-to-be husband, Chad Daybell. So let's talk about the motives of this case. Money. We see that from the text messages and the anger that you see through them when she learns that that's been changed and she's not going to get it. Chad Daybell. We didn't go through those text messages, but you can look at them. They are already very romantically involved by the time that Charles is murdered. And it's clear that Chad knows exactly what's going on because he's asking her about the car, about the insurance. All of those things Chad knows. And then there's that religious belief system. The zombies, the Z's, the possessed evil spirits. And her being like Nephi. All a reason and a way to kill someone, just like Nephi, a justified killing. There's that first call when we talk about money motive to Banner Life Insurance.
And what was the cause of his passing?
Well, he was shot.
Okay.
So I don't know how I want to put that.
Okay. All right. And I hate to ask,
I know.
but is it?
Yeah,
you
I
can
know.
just say yes or no. Was it a homicide?
No, it was an accident.
An accident.
So what we hear here is Lori Vallow being untruthful to Banner Life Insurance. We'll talk about credibility later, but it becomes very relevant that even in the smallest of things, this defendant exaggerates, minimizes, and is completely untruthful to various people. We all know that she was not the beneficiary. She didn't. But we also know that Charles Vallow was not accidentally shot. She told the police she was there. She knows that her brother intentionally shot him. Of course, they want to claim it's self-defense. There's no accident about that when you shoot someone twice. Motives for money. What we see again here is Lori Vallow talking to Chad about the motive. Telling Chad about the fact that it was changed. I just got the letter from that insurance company saying I am not the beneficiary. It is a spear through my heart. Who do you think he changed it to? Brandon? Or probably Kay? He left nothing for JJ. What do we know? Again, we see that Chad knows about all of these things. And what does he talk about in that morning as you have those entire messages in Exhibit 230? It will be interesting if he got changed after he had 2 bullets to the chest. Again, as we talk about the murder, we have later in that day the message that I talked to you about. So it was probably Ned before we got rid of him. We, not I, not my brother Alex, but we did. And then the other thing in this text message that is of importance is the fact that Lori Vallow knew a month before she went to Social Security how much money she was already going to get for the death of Charles. Here she says, I will still get the $4,000 a month from Social Security. When we talk about that motive and the anger by this defendant over not being the beneficiary, we know that even on July 28th, so 10 days later, she goes into Charles's computer to find the change of beneficiary form. She texts that to Chad to show him, and she sends it to Kay and confronts her about it. Money. That's what she wanted. And Chad. So let's talk about Chad. The affair with Chad Daybell. We know that she knew him as far back as November of 2018 when she came here, when he came to Arizona and stayed at Lori's house. You were told by Detective Duncan that there were recordings on her Lori for Style iCloud account of Chad Daybell here in Arizona for that Preparing the People conference. You also heard that in the Lolly time, the later account that was created later, that in March of 2019, there were screenshots of flights to Idaho and back to Arizona with both Lori Vallow and Chad Daybell. This is during that time when she disappeared and Charles was taking care of JJ, and she's off flying to Hawaii and Idaho, living the good life with her soon-to-be husband. And then, of course, we know that come November 5th, she actually marries Chad Daybell. That KK Walker email address. This was that June 29th. Big change. What do we know? That on April 21st, she created that account. She used her own phone number in creating it. And then she sent messages to Chad Daybell, brother Daybell. You have that exhibit. She pretends to be Karen Walker and invites him to Houston, because that's where she is at that time. She offers to use Charles's money to fly him out there and that he can stay at the house with her and her husband. In June of 2019, we see that Lori again uses that same account, but this time she pretends to be Charles and invites Chad out to Arizona to help him with a book. And again, in Exhibit 289, you have those letters. Charles finds those. And he lets everyone know he did. And he confronts Tammy, lets her know. Confronts Chad, lets him know. And he certainly lets the defendant know that he knows. And now the jig is up. We see in these text messages that were recovered from the iCloud accounts, whether they're under the Bubby context or under the Melanie 2 contact, this relationship between Lori and Chad. If you want to read the story, it kind of mimics them meeting in November, hooking up in hotels, and discussing their love for each other. When we are talking about a motive and a person who wants money and who has not worked for 13 years, who has had her husband pay for her homes, her phones, her cars, allowing her to go to the temple and work out and go to lunch in restaurants. This is a big change in life if she loses all of this. But if she gets $1 million, it's not so big of a difference, along with that Social Security she'll be getting. And then obviously we know that once Charles was out of the way, Lori and Chad were able to get married. But what about those religious beliefs? Everyone that Lori knew, who she expressed them to, told you that they were not in line with the Church of Latter-day Saints. Everyone told you that she said things like she didn't need to repent, she didn't need forgiveness, she could do whatever she wanted now, that she was in a celestial state, translated, that she is spiritually and physically changing, that she's above the priesthood, that she knew who was dark and evil. You saw those text messages, both about Charles and heard from people, as well as about Brandon and Zach and Adam. People who were helping Charles were also dark or Z's. And ultimately, what did we learn? That she associated herself with Nephi, a prophet, a holy man, who was justified and asked by God to kill Laban because he was an evil, wicked king who had the tablets that God wanted him to go get. Lori was just like that. She was justified in her killing. We heard from her brother, Adam, that their relationship had ended when she told him some things about her beliefs that he disagreed with, that she was turning into that celestial state, that she didn't need to eat, that she had more authority than the priesthood.
Yes.
You yourself personally, were you aware of Lori having outside? Lori having any beliefs that were outside of what is accepted by the LDS religion?
Yes.
Can you tell us what you were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
That's something that the LDS religion supports?
I haven't heard of it in that it's happened here on Earth yet.
Serena Sharp told us about, again, the not repenting and Lori changing physically and spiritually.
Members of the LDS Church?
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes,
What was it?
it was Ned,
N-E-D? Ned?
N-E-D.
Now, Serena Sharp was someone who met Lori in November, texted or talked with her for a while, and then was invited to that girls' weekend. One of the jury instructions you're looking at, and we'll talk about more though, is the credibility of a witness. Serena Sharp has no dog in this fight. She knew Lori for a little while. She was invited to, I'll call it the inner circle. The defendant told her some things that went against her religious beliefs. And she said pretty much after that, the defendant stopped talking to her. Now, how do we know she's being truthful? Well, we see Ned in lots of text messages. This just helps tell us that this is something Lori was telling lots of people, that her husband is possessed by this evil spirit, Ned. And we learn later that, like Nephi, she can get rid of him.
Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got, yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
The other thing that Serena Sharp told us was Lori using that term zombie. You remember how upset the defendant got by her saying that. But again, why would Serena make up any of this? She has no reason to. What she recalls is that that is a term that this defendant used when speaking of people like her husband who were possessed by these evil spirits. We heard from Christina Atwood as well, the same concept that Lori Vallow repeatedly would say.
Did she tell you, as well as the other women who were at this meeting in February, that her husband was possessed?
Yes,
So it wasn't just you in a private conversation.
correct.
She was open about it.
Yes.
So again, we see this ongoing timing of Lori Vallow talking of her evil, dark husband, who she later is authorized under her religion to get rid of. We know as well from Christina Atwood that there is a progression of these beliefs becoming more deviated from the LDS religion as she is meeting with her between February and June when she finally hears those words.
From the time you started meeting with these gatherings in February through to June, did you start to see sort of a progression of things that Lori was telling you that seemed outside of your faith?
Yes.
Did she make statements to you that you believed went against your religion?
Yes.
Did she at any point tell you that she did not need to repent anymore?
Yes.
What is that? What is that meaningful to you in your religion?
We believe that every single person outside of Jesus Christ has reason to repent.
Other than according to her words, to multiple people. So let's take all of this, the motives and this timeline now, and talk about some of the jury instructions and all the evidence that supports proof beyond a reasonable doubt that this defendant is guilty. I want to start with talking to you about direct and circumstantial evidence. You have a jury instruction that tells you that evidence may be direct or circumstantial, that direct evidence is the testimony of what a witness saw, heard, or otherwise sensed, and circumstantial evidence is proof of a fact or facts from which you may find another fact. You're told the law makes no distinction between direct and circumstantial evidence. And this is relevant. The witnesses have often been questioned. Did you see, hear, or do that? What you are told is you can actually use circumstantial evidence to convict anyone. But let me give you an example of this. Imagine you are sitting on a beach. Just you, it's quiet. Off to your right, there's some rocks and you can't see around that. While you're sitting there, a person walks by, you watch them walk by and they go around the rocks and you can't see them anymore. And then someone runs up 5 minutes later and they say, hey, did you see someone come by here? You say, well, yeah, I saw them walk that way. That is direct evidence. You saw it. Now imagine you're on that same beach and it's completely empty. You close your eyes for 5 minutes. Just relax. Before you closed your eyes, the beach was completely pristine. And when you open them up, now you see footprints. You can see the toes facing off to your right, the heels, and you see them go all the way around the rocks there. Somebody again runs up 5 minutes later and they say, hey, did someone come by here? And you go, well, I mean, I didn't see them, but they must have gone by in the last 5 minutes because you can see their footprints. They went that way. That is circumstantial evidence. You can infer from that that someone went by and where they went. The burden of proof. The state has the burden of proof, as we absolutely should. So let's talk a little bit about what it is and what it is not. You're told that the burden of proof is proof beyond a reasonable doubt. And the instruction tells you that that leaves you firmly convinced in the defendant's guilt. You're told there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. So I want to start by saying what proof beyond a reasonable doubt is not. It is not proof beyond all doubt. It is not proof beyond all conceivable doubt. It's not proof beyond all possible doubt, and it's not no doubt. You're told that there are very few things in life we know with absolute certainty. So just because someone says, what if? That is not a reasonable doubt. What you're told is it's proof beyond a reasonable doubt. As we go through the evidence and apply it to the crimes, we will show you that there is no reasonable doubt as to this defendant's guilt. So let's start with the crime itself. Conspiracy to commit first-degree murder. There are 3 stages in this, or 3 things the state must prove. 1, that the defendant or her co-conspirator caused the death of another person. Well, we know that Alex Cox shot and killed Charles on July 11th of 2019. Alex called 911. Alex indicated he was the shooter. He was the only one home. It was his gun. His credit card or debit card was in there with the gun. And we know that Lori told the police that her brother killed Charles. So we know that he caused the death of, so that. 2, that they intended or knew that she or a co-conspirator would cause the death of another person. When we are looking at this case, we are looking at the defendant's words, actions, and motive. The words and actions of having her brother Alex come over on the 10th with a gun so that he would be there when Charles came over to pick up JJ. The actions that day of taking Charles's phone, ensuring that he could not leave, that he could not take his son to school. The defendant told the detectives how angry and screaming Charles was about the phone, but she didn't just give it to him, throw it at him, tell him to get out, whatever you might do. She held onto it and told the police that she walked away with it as he's trying to grab it. The defendant's actions and words show us that she is the only reason why Charles stayed in there and the only reason why Charles was shot. Then there's those 12 minutes. Defendant tried to pretend that this was a quick, angry scuffle. But Charles is there for 12 minutes. The defendant is there for 12 minutes. Alex is there for 12 minutes before she leaves. We look at her actions when she came back. She told the police her brother was hit in the head with a bat. She never asks how he is. She's not concerned about his injury. She's not concerned about her husband being dead on the floor of her house, her child now without a father. The lack of words that she said there and her demeanor show again that she was well aware of what was going on and part of this incident. We look at her words to Chad, that Charles changed his life insurance policy before we got rid of him. They show her intent to kill Charles. And again, we look at the motive, money and Chad. When did this happen? The first time Charles came back into town after he found out about the affair. Finally, the state has to prove that the defendant or the co-conspirator acted with premeditation. So I'm going to talk to you about premeditation. You have a jury instruction for it, and it tells you that the defendant or the co-conspirator intended to kill another human being or knew she or the co-conspirator would kill another human being, and that after forming that intent or knowledge reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. You're also told an act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. This is where you remember those 12 minutes and the calmness of her walking around with that phone and her demeanor. You're told the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. So I'm going to give you an example. It's a lot of legalese, and then we'll talk about what we really have here. So imagine again, you are driving your car. You do every day. You're coming up to an intersection and you see the light turn yellow. And in that second you think, do I want to run it? Or do I want to slam on my brakes and hit it? Stop before I go into the intersection. You think about that, and then you decide, I'm going to slam on my brakes, and I'm going to stop. That is the time it takes to reflect. That is the time it takes for premeditation. But we have a lot more than this because we have planning, not just premeditation that morning. So when we talk about the premeditation that we see, it starts at least back in June, when we have Christina telling us about Alex Cox saying that he wanted to kill Charles, Lori having no reaction to that, and instead talking about drugging Charles.
Did you hear Alex making some comments?
Yes.
And You told us that they made you uncomfortable. What were these comments?
He stated he wished that he could just kill Charles.
Okay. Was Lori around when he's saying this?
Yes, one of the times.
Okay. So he said it more than once.
Yes.
Can you describe first part of his demeanor when he's saying this about wanting to just kill Charles?
It was jocular, just as I recall, he was standing up and just talking about it pretty loudly.
And you said one of the times that he said this, it was around Lori.
Yes.
Did she react in any way to hearing her brother say that he wished she could just kill her husband?
Not that I recall.
By July 9th, or when we start having this planning that we're talking about, we know that Lori Vallow is living in a house paid for by Charles Vallow. We know from even her statements to Detective Enclan that she doesn't like Charles, is what she says, but Charles won't file for a divorce. We know from her words and text messages that she wants to be with Chad Daybell, but Charles is her cash cow. She hasn't worked. He pays rent, car, cell phones, her travel. And so as far back as June 9th, we're already hearing that Alex and Lori would like to not just get rid of Charles, but kill him. But if you think that June 9th wasn't the beginning of this planning, this idea, this concept that Lori and her brother have of getting rid of Charles, this evil, dark, possessed person, that we know on the 9th that there is definitely a plan by this defendant. And we see that through those text messages with Melanie, with Summer, with Alex, where she speaks of the mission, where she talks about telling Melanie, you can't leave. You got to pretend to be sick and stay here and keep track of Brandon so he doesn't come help Charles. He can't be in the picture. We need to stay here to defend ourselves from an intervention. The 10th, again, we have Melanie who is talking to her and saying, that she wants to just go to this wedding. And what does Lori tell her? No, you have to stay here for the mission. The mission of stopping an intervention? No. As we continue through the 9th, we see Lori getting everyone lined up to help her. Alex, where he again is told that he will be like Nephi, just like her. Now Lori tells him it's an intervention. Everyone knows, Adam told you what's an intervention? It's talking to someone. It's common language. But that's not what the defendant wants to happen. She doesn't want Charles to divorce her and lose his money. She doesn't want this intervention to happen where she loses her temple recommend. What she wants is to be like Nephi and get rid of her husband.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him. And Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban? And
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
You heard from Detective Duncan that everyone he spoke with gave this same story. And again, the defendant questioned others about this story. But what we've heard is from Detective Duncan and from Adam that Nephi is this justified killing. When we think about her religious beliefs and what she's been telling people about not needing to repent, about telling people who is dark and evil, a zombie or a Z, that she is above the priesthood, it makes sense that she feels justified in determining who should live or die, just as she told her brother on the 9th. And we know that in fact we're talking about a justified killing because Alex brought a gun over. He didn't bring the Book of Mormon to talk to Charles about something. He didn't bring a friend to try to record Charles saying something. He brought a gun with him. And then he waited there for his sister's husband to come into the house so he could kill him. What we see is a very planned out, premeditated murder. But let's talk about some additional premeditation. Again, as we're looking at Summer, we see on the 10th that Lori is having her sister update her on where Adam and Zach are staying, so she knows they're not with Charles. They're not coming over. They're not going to be interfering with their justified killing. And there's that 12-minute time where the defendant desperately wanted to rewrite the timeline as they told the police that day. This just happened. It was very quick, but it wasn't. It was 12 minutes. Charles arrives at 7:37 and Lori leaves at 7:49. During this time is when that plan, that premeditated murder occurred. So let's talk about that as well. The evidence at the scene, the physical evidence, supports this premeditated murder. Alex fired 2 shots. One of them went through Charles' center mast, exited out his back, and went into the floorboard. The second one, Charles was on the floor, on his back, bleeding out, still able to move, and we know that because he had blood on his left hand, and he was executed as he lay there on the ground. In that time, when we talk about premeditation and reflection, as Adam had to move his hand down, reposition the gun, and discharge and pull the trigger one more time, that is premeditated first-degree murder, no matter what you believe before that. Again, when we talk about that physical evidence, we saw the fact that the location of that bullet defect in the ground matched right under Charles's left shoulder. And we heard from Dr. Baumgartner. Dr. Baumgartner told you that this was a classic shored wound. And no matter how many questions could be asked about him of maybe a bamboo shirt might stop a bullet in one location but not in another, or how many matrix-like hypotheticals where maybe Charles bounced back up and then on his way down, the bullet slowed down through him and waited till he hit the ground again before it exited. Dr. Baumgartner told you, no, those hypotheticals, those issues did not make sense. He's never seen a t-shirt stop a bullet in one location or at all. And we know Charles didn't bounce because we know he had no injuries to the back of his head. This also tells us a little bit about the shooting itself. When Charles was shot that first time through center mast, he did not fall straight back and land onto the ground, laying there on his back. If he had, he would have had bruising, abrasions on the back of his head when he hit the ground. He didn't have anything on the back of his head. Where did he have abrasions? On his knees. When he fell to the ground after being shot, do we know how long it took him to roll over, to fall onto his back before he was then shot a second time because he's still alive? You heard it could take up to 2 minutes for Charles to have died, and then he could have spoke and moved during that time period. What we do know is that he eventually ended up on his back. And while he was on his back is when he was shot the second time by Alex. This defendant and her brother in that house waiting and making sure that Charles was dead, murdered, executed. Words, actions, motive, and physical evidence all tell you what happened that morning. So let's talk about conspiracy. And I know there are a lot of layers here, and I'm just building them up for you. You're told in your jury instructions that conspiracy requires proof. One, the defendant agreed with one or more persons that one of them or another would engage in certain conduct. So again, we look to Lori Vallow's words. What she had been talking about for months, Charles being possessed, being dark, wanting to kill him, the discussion on June 9th, poisoning him or drugging him previously. And then when we got to July 9th, it is all coming to a head. We will be like Nephi. Her actions, having Charles come to the house, instead of him staying there, she had him stay away. Why? Because if Charles stayed at the house, couldn't have Alex come over with a gun and be ready to shoot him, right? You got to have him come in. Her actions of inviting her brother over with a gun the night before so he would be there. She knew when he would show up. He texted her, I'll be there at 7:30, pick up JJ. But most importantly, why did Charles stay in the house? Lori told the detective that Charles initially was like, oh, I'll just stay here for 20 minutes and then I'll take JJ to school. Well, she wasn't going to kill him in front of JJ. No, take JJ to Burger King. Get him out of the house. Go put him in the car. And he does that. But then she takes his phone. And she won't give it back. What she told the detective was, before this alleged Tylee bat, whatever thing you want to talk about there, that she had Charles's phone and was asking him about texting Adam. Of course, that's interesting because how would she have known that? But we know she had the phone actually for a while before she did that interview. She tells the detective numerous times that Charles is telling her to give him back his phone, and she will not. That she's walking around. He's trying to get the phone. She won't give it to him. Why? Because she needs Alex to come out. He brought that gun over for a reason. So she agreed with one or more persons, her brother, Alex, that she intended to promote or assist the commission of such conduct. Well, of course, we know both the promote. She is the one who on the 9th said, we will be like Nephi. It's time to stop this whole thing. Charles trying to take my temple recommend, all this stuff that's going on. Time to kill him. And of course, she assists by ensuring that Charles stays in the house when she takes that phone. And of course, they knew that it would constitute first-degree murder. That's what Nephi did. Only unlike Nephi, where it was justified, here, ladies and gentlemen, this murder was not justified. Finally, think about the demeanor when you're thinking about, again, words, actions, motive, and demeanor. When Lori comes back to the house, she is very, what did we hear that word many times? Nonchalant, calm, no questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that. So when we talk of the scope of conspiracy, you're told that to prove a conspiracy, it is not necessary to show a formal meeting or express agreement. But we see that from the 9th in that conversation that she and Alex had, where she tells him, you are going to have to stay near me for the next couple days, and we will be like Nephi. You're also told that a conspiracy may be inferred from circumstances showing a common criminal objective. So, because you don't have someone who says, I heard them say, we shall conspire. You can infer that from the conduct of what happened on the 9th, the conduct of what happened on the 10th, and the conduct of what happened on the 11th. All infer to you a conspiracy of Alex coming over with his gun to shoot and kill Charles. As we again look at this in this conspiracy, again, we're looking at the same words and actions. March, Charles is no longer there. There's just an evil spirit in his body. June, Charles is still possessed, and now Alex is saying he wants to kill him. Lori is fine with this, and she says she's drugging him or had been drugging him. And then 2 weeks before, all of a sudden, Charles knows Lori's been having this affair. Lori's words, actions, motive, and the physical evidence. Conspiracy, again, we see that Lori and Alex know exactly when Charles is showing up. Alex doesn't go to the door according to Lori and confront Charles or tell him we'll send JJ out and you can leave with him. The world is so difficult. How hard would that be? Bring JJ right to the door and let him leave with his dad. No, you aren't going to shoot him outside. You want to make it look like self-defense inside. As you go through this and we think about what's going on, The defendant doesn't even care. She wants her husband killed so bad that she's willing to let her brother bring over a loaded gun in an unlocked gun case in a house with a 7-year-old autistic child. That's fine. When the defendant was questioning Detective Enclan, she was talking about how hot it was outside. JJ's out in the car. But she has no problem with an unlocked gun in the house with the kid, and she's worried about her child out in the car. She's not. We know that because she's the reason Charles doesn't go back out into the car and leave. She keeps him there in the house. She is why JJ's out in the car alone. She has to keep him there until Alex comes out and can shoot and kill him. When we talk about that premeditation, obviously we're talking about that message. We know from the 9th on, they are premeditated, they are conspiring, and it's all heading to July 11th. We look at the timing of this, and this is actions and non-actions. Charles is in the house for 12 minutes. After those 12 minutes, they wait 47 more minutes before they call 911. Why? To stage the scene. No CPR is performed. They wait for Charles to be dead, and then they talk during this time period. They talk. They could call 911, but nope, they're going to just talk. So again, you're looking at their actions, what happened and didn't happen, and the motives. There's the gun that was used to kill Charles. We're going to go through a couple of these exhibits, some of what Lori said, and it's exhibits 192 and 197, where she again says that Charles came over and said he was just going to hang out at the house for like 20 minutes. Take JJ to school. She, of course, tells him to go. And when JJ is out in the car, she has Charles's phone, and she won't give it back. And no matter how much she says that Charles is screaming at her to give the phone back, she won't. And all of this conversation about Charles demanding the phone back is prior to her statement to Detective Enclan that Tylee comes out with this bat. This is all her doing. This is her as an accomplice assisting and promoting this murder. Lori is setting up Charles so Alex can shoot him.
And with JJ?
And so he put them in the car,
Okay.
in the driveway, and then he came back in, right? So I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, give me my phone. And I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's plotting something against me. Like, I'm like, why are you even here? Like, what did you come here for? You know, he's been talking to my other brother, and my brother came into town at the same time last night. And I haven't talked to my brother in a while, my other brother. And I was like, and so he was texting him on the phone when he first got to my house. And I'm like, why are you texting Adam? Like, do you even talk to him? Like my other brother.
So when you listen to these clips and the interview of Lori Vallow, you have to put into context, this is 9:52 in the morning when this part of this interview is occurring. And she's telling the detective that she confronts Charles about texting her brother Adam. Now, she's had the 47 minutes she's been driving around, and then that time at the house when she's waiting outside to learn all of those texts and what's been going on between her brother and Adam and Charles. And so she is now mixing this in to her interview. And so when you're listening to her interview, we know she's trying to work out this, what happened? How did this go? You can watch her demeanor as well. And as you're going through this, see how she's just telling a story here, like what happened, almost chuckling about it.
Okay. So this morning he comes back in and.
He comes back in, I wouldn't give him his phone, he was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there and he was screaming at me. And I was kind of walking around the house with it so he couldn't get it. He's like reaching for it and stuff like that.
So again, JJ's in the car, Tylee's not out, Alex isn't out, and she is making sure that he doesn't leave. She's walking around the house, holding his phone, refusing to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother Alex could shoot him. Let's talk about staging the scene. We know obviously from the first responders that when they arrived, no CPR was given. You heard from Officer Wierzbecki that when he felt Charles's neck, he thought he was dead already, but they still let the first responders in because they've been told CPR had been given. And what do we know? That they arrived within a few minutes. No one had ever tried to save Charles. No blood had been pushed out of him from CPR, whether strong or light. He had been dead for quite a while. His skin was mottled when they started cutting open his shirt and looking to the back, and lividity, the blood pooling, was occurring already. So they kind of knew something was off with that timeline. So what about the scene itself? The bat. It is placed to the right of Charles to look like he was using it. Got shot and went flying behind him. Well, obviously we've heard from Kay, Charles's sister, that he was left-handed. We know from the blood evidence on his hand, he was left-handed. There's no damage to that mirror. There's no damage to the drywall. There's no damage anywhere, like this bat is being swung around in this horrific fight that's going on of grappling. The injury to Alex Cox's head, you heard it was a small 1-inch cut that he was using a paper towel to pat, and at times, as you watch that Exhibit 1, rubbing it, making sure it stays bleeding. There is no blood at the scene from this giant grappling thing going on that Lori Vallow wanted them to believe. His head is bleeding and they're grappling around and he's being beat with this bat, and yet not one drop of blood on the floor. Not one drop of blood going down the hallway when he put that gun away. Not one drop of blood on the gun itself. And then the shoes, left by the door to look like Lori Vallow had run out in fear after this horrific incident that they planned. But we know from the Walgreens video is that she did enter the store with shoes, something on her feet. So we're going to go through. We know Charles again, left-handed.
With your brother.
Yeah.
What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Did he do everything left-handed?
Yes.
Right, left-handed?
So we know that Charles batted left-handed, not right-handed. And what we know is Lori Vallow had a story about how Charles was using that bat. And it becomes very important as well when we're talking about the staging of the scene. This is Exhibit 193.
Yeah, she was outside,
And what happened?
then they got up from that, and my brother had like stepped back, I guess, and then Charles was coming with me at the bat, yelling at me to give him his phone still, because I had it in my hand. It was all really quickly. And then when I went around kind of in the circle, then my brother was there.
When you said when you were going around and he was coming at you with the bat, how was he holding the bat?
Just like that, like backwards.
Like he was swinging it backwards? He would have done like
he would have swung it backwards at me, not frontward.
Okay.
So Lori Vallow detected and planned that Charles is swinging the bat backwards. Now, if the bat was like this when he was shot, his arm would have been shot. Covers his center mass. So we know he wasn't here. So if he's out here, where would the bat go? Down, out, somewhere that way to his left. It would not end up thrown up above him. And if it wasn't there again, Charles would have been shot through the arm. Obviously, Alex forgot that Charles was left-handed. So when he placed that, like he was coming at him with a bat, their stories didn't quite match up with the evidence. So if we rely on Lori's story of how Charles was holding the bat, then there's zero way that that bat would end up where it ended up. And again, we know he's left-handed from not only Kay, but his own admissions of that blood on his hand. So we see the scene is staged, this bat that is so necessary to try to ensure this justified killing is legally justified and not just spiritually justified. When we talk about the scene as well, and you're looking at where Charles was, at least when that second shot went through him, you can see in the photograph to the right, the shot to Charles's chest, right between his nipples, and the shot to Charles's abdomen down lower. We know that that first shot through his chest, that Charles would have been facing a little more towards the open area there where we see the hallway and the kitchen. We know that because there was the bullet trajectory Detective Coons told you about that entered that far east wall. We know there was stippling, and so the defendant would have been, well, her brother would have been within 2 to 4 feet of the muzzle of that gun within Charles, 2 to 4 feet. We know from the lack of that injury to the back of his head that he didn't fall straight back. We know from the blood on his hand that he was still alive after he was shot. And we know the lack of stippling for that shot to his abdomen and that trajectory, and even the defendant's own statements that she saw her brother at Charles's feet, that he would have stood there at Charles's feet when he fired that second shot as he was laying on the floor. You have the bat, Exhibit 249. You can look at the edge of it. You see the photograph of the edge of it. There is no blood and no damage to this bat. Regardless of how many times the defendant was hoping that blood was invisible, we have all cut ourselves and seen that blood is red. And there was no blood on this bat. There is no blood on this bat. There is no damage to this bat. So you have a semi-professional baseball player who has a bat in his hand, and he sees someone with a gun and doesn't beat him with it, take his head off with it, knock him unconscious with it. Instead, all we see on this bat is 0 damage and 2 partial prints. No prints of a body or smushed skin on it. Someone that's sweating from a fight that's left a large arm print on it or anything else. Nope, just 2 partial little prints on it. When you think about what is there and what isn't there, does the evidence of this bat fit in at all? It doesn't. We look at Charles's watch. No damage to it, no scratches to it, no dings to it as he's grappling on the floor like Lori wants you to believe. We know that at some point, Charles is standing and shot, and we know that final shot, he's on the ground. We know he fell to his knees at some point. And when you look at that physical evidence and the lack of damage or anything on that bat, again, what makes sense is that Charles fell to his knees after that first shot. We know that there is 12 minutes where the defendant and her brother are still together there, so that Alex can get this 1-inch cut to the back of his head that's barely bleeding, that he uses a paper towel to dab at and rub. The shoes that the defendant ran out of on her way out. You have the exhibit. You can see black straps across her toes as she enters and exits the Walgreens. And then you see that she's wearing the flip-flops when she comes back to the scene. What do we know? That the police did not search Charles's rental car. Credibility. You are given a credibility instruction and you use it for everyone, including the defendant. You're told that you really evaluate people the same way. You're looking for any inconsistencies in their stories, any reasons why they may have a motive or bias to lie, any prejudice they may have, and then you look at everything in light of reason, common sense, and experience. When you think of the testimony of the people who come here and talk to you, Christina Atwood, Serena Sharp, Nancy Jo Hancock, Adam Cox, Dr. Bumgardner, the detectives, Robin Smith Scott, Mark Sari, what benefit do these people have in being untruthful to you? They have body cameras, they have prior documents, and they have memories of what this defendant said. But the credibility of Lori Vallow is something you do need to consider. And you start with her demeanor that day, where she wasn't worried about anything when she arrived. Her brother has allegedly been hit in the head with a bat by her husband, who plays semi-pro ball. She doesn't even worry about him. She knows he's not hurt. He's fine. And why does she know that? Because that was staged. When she's there and we see her on body cam arriving, she's just nonchalant and calm. And I know the defendant wanted to make sure that it was clear that everyone else was calm, but no one else had just allegedly seen their husband get shot and killed by their brother. When you were looking at the reasonableness of her testimony, you have to consider it in the light of reason, common sense, and experience. And the way that she was acting and reacting that day, as well as her own statements, do not fit the evidence, do not fit the physical evidence. And you will see her credibility throughout this whole case has been questionable. Her credibility with Social Security. What did we learn? That on July 11th, she tells Detective Enclan that she and Charles are separated. Exhibit 187. We are not living together. Charles rented her house. We're separated. But on August 12th, when she needs to make sure she gets some money, she tells Social Security, when they ask, are you living together at the time of death? Yes. You also learned that she was not truthful with Social Security when she got remarried. She did not tell them about that either. So we know she's been untruthful to Social Security twice. Why is that relevant? Because you're judging the credibility of Lori Vallow throughout all of this. Life insurance. We know that she said Charles was accidentally shot. We know that was not true. She wanted to make things seem like she had nothing to do with the murder. But we know that Alex Cox intentionally shot Charles. Whether or not she wants to claim it's self-defense or not, there was nothing accidental about shooting him twice. Then that second call to Banner Life Insurance, where she tells Robin Smith Scott a few different things to garner sympathy, and she asked her if she could do anything about the change in beneficiary.
I really can't give too much information, but I can tell you that the beneficiary was changed in March of this year.
Okay. Okay, I'm trying to figure out what he was doing since we have 5 kids and we've been married for 15 years.
Oh, I'm sorry.
So Lori tells this woman, we have 5 kids, which if you want to count them all and admit that 3 of them are adults, then okay. Really, they have 1 kid in common. Tylee, you learned, was actually getting Social Security survivor benefits from her dad's death starting in 2018. Lori's son Colby isn't living with them. Charles' son's never lived with them. Why does she say these things? She can't help it. She just wants to just make herself seem better than she is. What about the credibility of her interview, even during the police interview? We've talked about a few things, but one of the things she told the detective.
And I didn't file anything or whatever. And then he filed something against me and said, I'm only going to get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days and let him take care of him and let him see what I've been doing.
So again, she can't even be honest and say 2 months. She's got to be like 30 days. I was kind enough to just leave my husband with my son for 30 days. What we know is that Lori Vallow was gone a total of 78 days, 58 while she's flying to Hawaii, going to Idaho and back with Chad. And who's taking care of JJ? Charles. And Kay is coming here regularly to help take care of JJ, to help run the business. And then eventually on March 28th, that's when Charles finally decides he hasn't been able to find Lori. He doesn't know where she is. He's going to move to Houston to be closer so his sister can help him more easily. And this is when Lori finally shows back up. So again, even the simplest thing of just trying to be honest about how long she's been gone, she has to minimize it and make herself seem better.
With your cross.
The shoes. If this will play. When she was questioning Detective Enclan, she was asking her if it was hot in July and if she would need shoes to go take her son to school. But of course, what we know is that we saw her with those shoes on as she went into Walgreens. So again, it's continued trying to garner sympathy and just being untruthful about whatever she feels like being untruthful about. And then we look at the credibility in that timeline, that body cam.
Well, you know, now that you're not in Santan, this is your home.
Right,
Gotcha.
right. We just moved in here.
Gotcha. How long have you guys lived here?
Okay.
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah. Okay.
That's why the neighbors don't know us.
Gotcha.
Like, hi neighbor, sorry.
Are you working?
So here she is, 47 minutes after leaving the house, laughing and smiling with the detective about the fact that her husband is dead inside the house. Her brother is sitting on the curb, allegedly with this very serious injury from a baseball bat. When you look at that credibility of the defendant, you have to look at everything together and what fits, again, with the physical evidence and what doesn't. Finally, let's talk about the justification defenses. What we know is that Lori Vallow thought she was like Nephi, that she was justified in killing Charles. that her brother, who was supposed to be like her, was also justified in killing Charles. But Lori Vallow is not justified under Arizona law, nor is Alex. So let's go through the different justification defenses. First thing that you have to consider for every one of these, self-defense, defense of a third person, or crime prevention, is the non-justification for use of deadly physical force. You are told if a person is not justified in using or threatening physical force or deadly physical force against another in response to verbal provocation alone. So Charles yelling and screaming at her to give his phone back does not justify you shooting him. Or a person is not justified in using or threatening deadly physical force if the defendant or co-conspirator provoked the other's use or attempted use of unlawful physical force. So we know here Lori provoked Charles by taking his phone and refusing to give it back. So again, when we look at every one of these defenses, you'll see not only do they not apply, but none of them is the defendant entitled to. This is not self-defense. In self-defense, you're told that a person, a reasonable person, can use deadly physical force if they believe that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in this situation. We know that Lori Vallow used Charles's phone to get him to come back inside, and she used his phone to keep him inside and give her brother time to come out and shoot and kill Charles. We know from the physical scene itself that Charles did not use a bat. We know from the physical evidence of Alex's 1-inch cut to his head and the lack of blood or concussion, the lack of damage to the mirrors, the walls, the location of the bat in relation to Charles, they all tell us that Charles did not use a bat. We know that Charles was a semi-professional baseball player. This would not have ended that way if he had had a bat. But even if you somehow think that he did have a bat and he was swinging it at Alex, the defendant, whoever, he still was not justified in shooting him when he was on the ground. It has to be immediately necessary to protect against another's use. When Charles is on the ground and he is shot that second time, there is no threat to anyone. And so that is not self-defense.
Counsel, I need to give my court reporter a break unless you think you'll be done in the next 5 minutes. Okay, go ahead.
When we look at the physical evidence, again, we know that Charles was on the ground, shot, and so this is not self-defense. And we know from the physical evidence at the scene, projectile into the floorboard, this is not self-defense. Third party. You're told that a person is justified in using or threatening deadly physical force in defense of a third person, I presume here Lori Vallow. If a reasonable person in this situation would have believed that deadly physical force was necessary to protect against another's use, again, of unlawful deadly physical force against a third person, and they used only what was necessary for a reasonable person under the situation. What do we know? Lori Vallow told Detective Enclan that she wasn't even in the room when she heard the shot, that she had gone around into the kitchen. Who's he protecting at that point? What third person that's no longer there is he protecting? You can't protect against a future, what might happen, or what already occurred. It has to be now. And Lori Vallow herself put herself outside the room when her brother shot Charles. So there is no third-party defense. But again, the same thing applies. Even if you thought so, that second shot removes any possibility of being justified. Crime prevention. This is the exact same thing, only in a slightly different stated way. But like self-defense, it allows a person to use deadly physical force against another to the extent a reasonable person would have believed that deadly physical force was immediately necessary to prevent Charles from committing aggravated assault against Lori Vallow. We know she's not in the room. Even if he had that bat and had been coming at her and then she left the room, that crime is over. And again, even if you believe he had the bat, you cannot shoot him while he's on the ground. That is not what crime prevention permits you to execute a person. Finally, there's mere presence. You're told that guilt cannot be established by a defendant's mere presence at the crime scene, mere association with another person at the crime scene, or mere knowledge that a crime is being committed. Lori Vallow wasn't just present at this crime scene. She brought her brother to the crime scene. She ensured that he brought a gun with him. She ensured that JJ was outside, and she ensured that Charles stayed inside. She was not merely present. She was a person who was actively participating in this crime. Ladies and gentlemen, we have talked about the evidence in this case. Evidence that was presented to you through witnesses who took the stand and exhibits that were admitted for you to review. Remember the evidence of Lori Vallow's motive. Charles's life insurance, Chad Daybell. Remember Lori Vallow's own words of wanting to get rid of Charles, of drugging him, her acceptance of her brother's statements that he wanted to kill Charles, how she used Melanie and Summer to plan her mission and ensure that Charles didn't have help from Brandon or Zach or Adam. Her words to Alex about it all coming to a head, that he had to stay near her and they would be like Nephi, justified in killing Charles. And finally, her words to Chad Daybell on July 18th, confessing to the killing when she said Charles had changed the life insurance before we got rid of him. Look at her actions and demeanor, having her brother come over on the 10th to her house with a loaded .45 caliber handgun, creating the one and only reason why Charles stayed inside the house, why he didn't just take JJ to school. The 12 minutes that Charles is at the house before Lori leaves in the car, the 47 minutes after that before they call 911, her demeanor when she comes back, not caring that anyone has been hurt, her demeanor on the body-worn camera, during her interview, what you heard about during the drive. Think about her credibility, how she cried for you in her opening statement. You certainly didn't see her cry on that body camera footage. You didn't hear about her crying as she was being driven to the Family Advocacy Center, and you did not see her cry in her interview. Finally, think about the physical evidence that proves that Lori and Alex staged this scene, that Charles was never in possession of that bat when he was shot by Alex or either of the shots, that instead he was executed that day for this defendant's benefit. The physical evidence disproves beyond a reasonable doubt that Lori Vallow and Alex Cox were justified under the law in killing Charles. The jury instructions tell you to use reason, common sense, and experience. Charles Vallow is dead today because this defendant and her brother Alex Cox conspired to kill him. They planned it out, and they had their weapons, and they orchestrated a way to ensure that Charles was back in the house where he was shot and killed for money and Chad Daybell. The evidence proves to you that Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder, and the state asks you to hold her accountable and find her guilty. Thank you.
All right, we're going to take our 15-minute afternoon recess. I'll remind the jurors to remember the admonition. We'll resume in 15 minutes.
You actually could see a little bit of a smile when Trina was walking to the car or to her table. Did you see the little smile she had on her face? Like, take that, you mother trucker. She was just like, take that. Like, that was so good. Now, it was long, but she needed it. She needed it. It was so good. And now, just the crappy thing is, though, is that we have to do a 15-minute break because Lori would be so riled up that she can't come down. She would have to go right up. That was so good. The slams she was doing was fire. I mean, I had to take a little bit of I had to leave the room for a couple minutes. But it was fire. Hypothetical bamboo shirt. It was so good. Yeah. Lori is mad, but I wish she was going up right away. What is she going to say now? I think it's perfect that Trina was poking her because now she's fired up of all the things that and she said, I quote, she wants to make herself look better than she is. You can't even make that up. It's so good. Like she just kept going and going and going. Her analogies were really great. It's so good. But that little smile at the end there from Trina was gold. She's like, how you like them apples? You know what? She's using the B word in her head. Lori, don't flatter yourself. That was so good. Nicole says that she will say the evidence does not show. Interlocution says, I think we'll have a verdict today. That was so good. What I love about it is she laid it all out. She used we got rid of him 4, 5 times. Beautiful. Thank you, Trina. That's what we wanted. She played the high neighbor. Thank you. You guys, she said about the shoes. I had to miss it. That she talked about the shoes in Walgreens. So you got to give me the lowdown on that. I hope she's still steaming in 15 minutes too. So good. Trina left nothing on the table. And the beautiful part is now Lori comes up. She has her little diversion, her verbal vomit diversion, and then Trina can come back up. So maybe Trina's even leaving some best for last moments. It was so good. I love that. She mentioned that she had flip-flops on Walgreens. She hit everything. I wish she would have talked about perjury. Kim says, yeah, tell me what your favorite part is so far. I enjoyed when she talked about Lori's opening statement. She was crying, but didn't cry in any of the videos. And then she said, Lori, Vallow, Daybell. She said she walked into Walgreens with shoes on. Yeah, that's exactly it. She had a smile on her face. It was so good. That was really, really good. Good job, Trina. Good job. Great job. Great job. I wish I could see Lori's face too. We got rid of Ned. Favorite, we got rid of him. Zobo Rose says Trina left no crumbs, as the kids say. Justice for Charles. Adam, last quote is a finish line. There's no doubt in my mind they killed Charles. Paulette says not self-defense with 2 shots. Mary Marlowe says, so glad to see you back. Stay strong, sweetheart. Thank you so much for the super chat, and thank you for your kind words. I truly appreciate your guys' support. Rachel says, I love that they showed clips from witnesses to refresh the jury's memories. It was so good. HD says, that was so great. I don't know how this jury could find her not guilty. Silent One says, I like that she mentioned that Charles fell forward first and shot number 2 was an execution. Maureen, nice to see you. The videos were my favorite part, backed up by her words. Apparently we are behind, but my live stream is live. Thank you, Julie B, for the super sticker. We are a delay with East Idaho's live stream. It's coming. Love you too. Thank you guys for being here. Kathy says, love to get rid of. Granny says, I need to go and make a dressing to go with Lori's upcoming word salad back in 5 minutes. Thank you. Peter says, I liked it when it blew out my eardrums. Yeah, I heard that going. Jag Girl says, I have been with Linda since Chris Watt's case. 5 years. That's 5 years ago. Wow. Thank you for hanging out with me all those years. All these years. People are forgetting about the 30-minute delay. Thank you. Jill says, thank you for all your coverage. Linda, thank you. Thanks for the super chat. I like doing this with you guys. I love our laughs. I wouldn't trade that for anything. You're welcome. Thank you, Dodie, for being a moderator and being with me for a long, long time. Yeah. So we're going to be hearing from Lori pretty quick. And we want to do it all together and see how it all ties in together. Leanna says 144,000 shots given by Trina. Yeah, there is no disputing that. That closing was awesome. Jury is not deliberating yet. We still have to hear from Lori. Hi, neighbors. Nice to see you again. Thank you. You guys are so sweet. Yeah, right, says, thank you for no ads. You are very welcome. Those go on after this. I wait till the end and then I put the ads on. So we don't have to be annoyed with them. I know, it's so good that we're together. I know, Suzanne, that's another case. Maybe one day. I'm so glad to be back too. You'll see more of me now. I know. It's been a long time. Can't believe it's been 5.5 years now. December, January, February, March. 5.5 years that I've been doing this. Janelle says, has anyone watched the video of Charles' ex-wife being interviewed sticking up for Charles? Yes. Now, I don't remember if I had it on my channel. I think I do. I know. What can Lori actually say now? She's going to have to really create a diversion. What is she going to do? She might have to pull a Letitia and fake something. I don't know. Summon Eduardo Omeletto. Basket of deplorable garbage says, Lori will tell the jury, yes, I did have shoes on in Walgreens, but I needed flip-flops for my pool party, plus my shoes were all bloody. No kidding. I do need to write that book. My mouse clicks are totally ASMR. It's on my MacBook. Stephanie says, I'm not sure how long I've been watching your videos, but I do know it took me years before I made any comments. I was a little shy in my younger years. I will follow the Koberger trial. That's starting August 11th, and it's going to be 3 months. So you guys are going to watch me for 3 months. Thank you, John. Thank you so much. That was so good today. I'm so glad she pulled the we had to get rid of and just like slam dunk it. Thank you. Thank you, Blue Tulips. She might pull a Letitia. Lucky Pineapple says, I remember when Linda's 144,000 sign hit 11,000. I love your ability to decode details, and I love that you say everything we're all thinking. Wish you had covered Delphi. I did up to a point, but I did take some months off. It was a little rough, but I'm here. The members can put the Eduardo Omeletto. I have an emoji for that. Oh, there we go. Thank you for putting it up. You guys are very sweet. I wonder why the feed is so behind. Is that weird? That's weird. Wow, 27,000. That's a long time ago. Just let me check something, guys. This is where the stress comes. Hang on for a sec. Okay. Here we go.
All right, please be seated. The jury is present. The defendant can proceed with her closing argument.
Let's see her go.
Ladies and gentlemen of the jury, the state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911 and was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show. Go ahead.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews or let you listen to the 911 call.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the three of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all three of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all three of our cars were inside the police tape. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inklin to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet we were told by Detective Duncan, the case agent on this case on the stand, that because of some problem, the walkthrough is not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have in evidence any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only three witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained. The jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to determine what the facts did or did not establish.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was self-defense and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever. How are you supposed to choose between 3 people you love? Your husband, your daughter, your brother?
All right, hold on. All right, I'll caution the defendant not to testify about things that were not entered into evidence.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
It's a reasonable person standard, not the standard of the person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
Right. Sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy. That's all.
Sit down, Lori.
All right. The state does have the burden, so I have the right to open and close the argument. Do you want to give a rebuttal close? Go ahead.
What a little bunch of. As Katrina says,
The execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt, albeit it is quite obvious. This defendant wants you to just look at one piece, and she wants you to hope that there's only a person who will say, I saw, I heard the conspiracy. But what did you hear in every instruction is that you can look to other evidence to show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? That they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those we, because she's writing it.
She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning for something, that those words don't mean exactly what they are. We got rid of him, this defendant. The state, of course, has the burden, and that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy. That is planning. That is premeditated. You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful, as we've gone through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on Charles and at the scene show us that he was executed. And every single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground. The defendant wants you to believe she was shocked and surprised by this, and yet she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day, when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying, and then all of the evidence after that, culminating when this defendant told
the man that she married later, that she was having an affair with, as many times as she wants to say Charles was my husband, she didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder. Thank you.
All right. Do we have Izzy coming over? Izzy to be sworn in? All right, members of the jury, there are 14 of you, only 12 of you can deliberate. At this time, we're going to choose the alternate jurors by random lot here. So we have our scientific method here of random numbers.
14.
Juror 14. Juror 5. I don't think you're 5. Well, maybe you are. Okay, so to the alternates, if I don't see you again, I want to thank you for participating in this process. The admonition still applies to you until we call you and tell you that it's been lifted. I have in the past had to have callback alternate jurors to testify or to deliberate when, for whatever reason, one of the jurors can't continue to deliberate, becomes sick, has a family emergency, etc. So you still could have to deliberate in this case. But again, if I don't see you again, I really do want to thank you for participating in this process. I know it might be somewhat of a disappointment to not deliberate right now, but we will keep you posted and we'll let you know if we need you. The remaining 12 jurors will retire to the jury room and begin your deliberations. First, we're going to swear in my staff.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication? And when they have reached a verdict, you will bring them back into court without revealing the verdict to anyone, so help you God.
Izzy, drop those off. Undrop those off.
All right, so the jury.
Okay. What do you guys think about today, about Lori's BS? She's doing such an amazing job. Trina's like given
The jury's no longer present in the courtroom. I've passed out proposed aggravation phase jury instructions in the event that there is a verdict of guilt. The state elects to proceed with an aggravation phase of this trial. So I'll let the parties review that. It's not too long. Got it. All right, we'll be at recess until we hear from the jury.
All right.
Okay, well, we're in deliberations now. So I guess now we wait. We're on verdict watch. This should be interesting. I don't know how we're gonna do this, but we'll see. We're gonna have to be watching. Innocent because of the luminol. Let's check in on our poll, shall we? Almost 2,000 votes, 93% guilty all the way, 6% I'm not so sure, and no, based on the trial, she be not found guilty. So we'll see what people think. This is about almost 2,000. And if you haven't polled it, I'll give you the link and you can be part of the poll. Okay, somebody said possibly the jury went home, but okay, looks like they have. Okay, well, we'll talk for a little bit and then we'll see what happens. And jury did not go home. Come on, people, common sense. I say by 7. Oh, you didn't know what the picture behind me? Charles has been with us the whole time. It usually actually cycles, but since this trial, I put it on. Amanda says, thank you, Linda. I won't watch these with anyone else. I've introduced my baby brother to your channel. He's currently watching with me. Hi, Ray Ray. Okay. Nate apparently reported they went home. Now, we're on a half an hour. No, we're not on a half an hour delay, are we? We were on a 5-minute delay? I don't know. Trina did an amazing job. Okay, you guys are saying that they went. Please hit the like button. That helps out everybody involved. I know you like the stream. I'll do more of it. And oh, the 5-minute delay is for verdict. That's right. What are we gonna do? The 5-minute delay when the verdict comes in. That's gonna be tough. And then are they gonna give like a good time as a heads up? Because I gotta go to soccer practice tonight. Cher says, what do I think? The jury doesn't know all we know, but hoping. P.S. Couldn't they admit the video when Charles talked to the police? No, they couldn't because it follows the hearsay rule/law. So no dice, Cher. Thank you so much for the super chat. I appreciate it. Court TV says jury is deliberating. Like, wow, this is hard to. Lori will be selling trips in her portal to raise commissary. Trips start at 144,000. Ashley says I will never look at Shih Tzus the same. I don't think I can either. Okay. Last I heard was an hour notification for family, then 5-minute delay when they go to court. Okay, well that's okay, right? Yeah, and let me just check one more thing here. Oh, Mary, thank you so much. She gifted 5 It's a Crime membership. Thank you. Okay, Nate, let me just see something. Here he is. Sorry for the silence for a minute, guys. I'm just trying to see. No, I don't see it. Super Salty says, 31. Where did, oh, on Facebook he posted. When do they come back? Carl. I do like listening to Linda's content. She's very fun to watch as well. However, the comments are mostly women, 1 or 2 men. It's like surfing through TV and stopping on the program of you. Well, here's the thing. True crime is actually like 80 to 90% women, and we welcome men. In fact, more men are welcome on here. But hey, we're after the same thing, and that's justice. So, right? Let me just check again on Nate. I only see on Nate, I only see 2 hours ago, and then I think I saw one from 1 hour ago. I don't know. Back tomorrow at 10. Now, Susan says they're still there. So we have 7,000 different. Hang on. Okay. Justin Lum says the jury deliberated for about 10 minutes before deciding to call it for the night. Deliberations continues tomorrow. That's interesting. They only deliberated for 10 minutes and then called it for the night. Don't you find that interesting? Because it's only 4 o'clock there. Not even. That is weird, isn't it? I just find that it is weird. Let me just double check something. Yeah, so Justin said the jury deliberated for about 10 minutes before deciding to call it for the night. Deliberation continues tomorrow. Well, I guess the good news is I don't have to stress out at outdoor soccer. In the snow. Yeah, 10:30 tomorrow. So it's 11:30 here. So we'll be back. We'll do live stream again tomorrow. It'll be 11:15 will come on my time. And then I'm not sure if we're on jury watch. I'll have to come up with something here, what we could do. Or we'll see how best to do it. Sarah's mad. They voted and decided to sleep on it. But that's okay, right? So, we've been going for 5.5 hours. It was a good day. Lori looks like an absolute idiot going pro se. So, welcome for Brandon's trial too to be an idiot. Basket of deplorable garbage says, Linda, I've been with you since 2019. You've never let us down. Thank you for covering these very sad cases with such accuracy in class. You're welcome. Thank you for being here. Thank you so much, you guys. Okay, so my butt is numb, so I'm going to get up and go. But I very much appreciate you guys. We'll be on jury watch for tomorrow. And then we can celebrate together when Lori gets another guilty verdict and she can rot in jail. I mean, in prison for the rest of her miserable lolly time KK Walker life. Lori was terrible today and I'm here for it. She had nothing to go on. And Trina brought the fire. She brought the snark. She just threw it all in a pot and let it simmer. So thank you so much. I love you guys. I appreciate you. We'll see you tomorrow. Bye.